A 15-year-old girl named Carly Gregg did something that will define the rest of her life.
According to the prosecution, she shot her mom twice in the head, tried to shoot her stepfather.
She looks like a little girl. She is a little girl.
You don't just wake up and kill your parents.
This seemed to come out of nowhere.
The deadly daughter murder trial.
14-year-old Carly Gregg was a really good student. In fact, she was Student of the Year at Northwest Rankin High School in Brandon, Mississippi. Carly's mom, Ashley Smiley, was a teacher at the school. She was married to Heath Smiley, Carly's stepdad. One day after school, after Carly and her mom got home, Carly can be seen on video seemingly sneaking around the house. She then goes into her room to confront her mother with a gun. She shoots and kills her, then contacts a friend to come over and sends a text from her mom's phone to lure her stepfather to the house. When he arrives, he is shot opening the door, but Heath Smiley survives as Carly runs away. Carly's on trial for murder and attempted murder, but her stepdad is on her side supporting her. The question for the jury will be, was she or wasn't she legally insane when she fired the gun?
Ashley Smiley, school teacher, loving mother, was killed by Carly. That is a fact. That fact's not really in dispute in this case. Yeah, prosecutors still have to prove it, but it's not in dispute. I'm not saying that didn't happen. It did. She was shot and killed. You know, Ashley did not expect that. Probably one of the last things she would expect to happen. That her daughter would come into the room with a gun, confront her, and shoot her 3 times and take her life. You have to wonder what Ashley was thinking in those moments. Like, is this really happening? Then we also know that Heath Smiley, her stepfather, was shot by Carly, and he told us what he was thinking. What he saw was like she had been possessed by a demon or had seen a demon. The shooting happened as he's opening the door, so he's not like he's having a difficult time in the moment processing everything that's happening, and not necessarily believing that she had shot him on purpose. But he survived, and he testified, and he made it very clear that he has a ongoing relationship with Carly, the stepdaughter who, according to prosecutors, attempted to kill him. He was shot, he was injured, but he survived. Now, she's on video inside the house. So one thing that we all can see, and obviously the jury can see, which we don't necessarily often see in a murder trial, is the immediate response and reaction of the accused killer. And that you definitely see here. And the big takeaway that almost everyone is having is how calm she is throughout all of this. So the question is, like, why? Why is she calm? Why did she do it? What is going on between her ears? This whole case is focused on her mind. You have to lay out the facts as the prosecution. You have to prove it. But at the end of the day, when it comes time to figure out what do we do with this, which is what the jury is being handed. What do we do with this? She was 14 at the time, now she's 15. We've got experts saying this and that about her. We know that she was medicated. We know that she had some mental health history going into this, but we've also heard testimony about her sort of breaking bad and having some problems going down a road that sometimes teenagers go down, and maybe mom was putting down, laying down the law about, okay, this is gonna stop. So let's try to figure out what's going on, where we are, and what's next. Joining us to help us break down this case, Court TV legal correspondent Kelly Craft, who's been in the courtroom today. Kelly, great to see you tonight. Some case, very unusual, given the age and the history of this accused murderer. But let's focus in on what the state did today in their rebuttal case. They get a chance to respond to whatever the defense did. What can you tell us?
Well, hi there, Vinny. The state put on quite the rebuttal case, calling witness after witness, medical professionals who took the stand talking about their evaluation of Carly Gregg. The state put forth a nurse practitioner who had 3 visits with Carly Gregg and her mother. So 2 were teleconference, but 1 was in person. Then they also put on a therapist who had seen Carly in person 9 times. So she talked about what her observations were, and also another doctor that was found by the state to do, this was a court-appointed doctor, a psychologist, who talked about her evaluation of Carly Gregg as well, and whether she was competent or not to stand at trial. But let's talk a little bit more about the therapist who she did see 9 times. This witness on the stand, talked about how Carly came to her and how she was talking about things like sleeplessness, how she was cutting herself. So that's been a big thing in this case, that Carly was doing self-harm. Also, that she just was having some internal thoughts that she needed to help manage. And her mother had told the therapist that Carly wanted to feel better about herself. Let's go ahead and play a little bit of her testimony.
On this first meeting, did Carly ever report to you any use of illegal drugs?
No.
Did she ever report to you that she was hearing voices of any sort?
No.
Did she ever report that she was having any sort of hallucinations?
No.
What about, did she ever report to you that she was having memory trouble?
No.
What about feeling derealized?
No.
Did she or Ashley ever bring up the word disassociation? And to be clear, I want to talk about the first day, but was there ever a time in your treatment of Carly that she reported that she was having any sort of blackout? Like there were times where she didn't remember what she'd done?
No.
That particular witness said it was the shock of her life, Vinny, when she found out that Carly Gregg had shot and killed her mother.
I could imagine, right? This is someone that you're treating, someone that you're seeing. So another part of the rebuttal case is the state calling their own forensic psychiatrist, the psychiatrist who goes in after the fact and tries to peel back the layers on the defendant and figure out what was going on, most importantly, at the time of the shooting. What can you tell us about the state's forensic psychiatrist?
Vinny, this testimony was pretty heavy, and as sitting inside that courtroom, you could tell the people in the gallery, a lot of times with some of his testimony, people in the gallery were turning to one another, kind of just mouthing, wow, with some of the things that he was saying on the stand. He was using words like diabolical and psychopathic tendencies, as well as deceitful. I was watching the jury as he was giving his testimony, and you could tell some of the jurors, when he first started getting going, found him very credible, because some of them were nodding their head like this as he was talking about the things, and he gave the opinion that in his opinion, Carly knew the difference between right and wrong. And what did he base that finding on? He talked a lot about this video that we all have seen, in which you can see Carly right there, what she's doing. This is after she had shot and killed her mother. She then grabs her mother's phone and then texts her stepfather, Heath, saying, honey, when are you coming home? So the person on the stand, the psychiatrist on the stand specifically talked about this, also talked about the dogs and how their reaction was, saying that even the dogs seemed to be able to sense that something was wrong. But Carly was saying to the dogs, it's okay, because she knew something was wrong, meaning she cannot meet the standard for insanity in the state of Mississippi. This is according to him. Why don't we listen to some of his testimony and some of his findings?
When Carly on that day went and unlocked the phone, texted a specific target, her stepfather, who she told me was more of a father figure to her than Kevin was, and said, when are you almost home, honey? Using that honey is an enduring term. I might use it for my family, a loved one. I wouldn't use it for a stranger. When she did that to me, that was very specific and diabolical. And that to me is not consistent with a dissociative spell. That is not consistent with psychosis. That is not consistent with mania. And it's definitely not consistent with hypomania. To me, that was deceitful. This conveniently puts her right beside the camera footage that then turns off and is later found hidden behind some water bottles in the refrigerator. I presume it's hidden. There were water bottles and it was behind it in the corner. To me, that strongly suggests somebody who's trying to hide evidence and avoid detection because they appreciated the wrongfulness of what they were doing. A psychotic person who's disorganized and doesn't know who they are or what just happened or where they're at, I do not believe would put the camera, take it down and put it in the refrigerator behind water bottles. This also, when she came back out, gives her a second opportunity in front of the camera to play cool. And she said to the dog, she kind of whistles and she says to the dogs, "It's okay."
Yeah, and that's when the doctor on the stand said when she was talking to the dog saying it's okay, that's Carly knowing that she did something wrong. So here in the state of Mississippi, the standard is the insanity to plead insanity. The doctor said she meets that threshold to kind of get her in the door. But then what you have to look at is, could she understand what she was doing? And did she understand what she was doing was wrong? According to him, he says she can.
And that's important testimony. And right versus wrong, right? So you're hiding a gun. Why are you hiding the gun? Do you appreciate the wrongfulness of taking a gun and carrying around in the house after shooting your mother? And then there's also the flight as well, running away from the scene. And then the luring as well. So this is important for prosecutors, right? If the jury agrees with this expert, she's got a big problem. So how did they cross-examine Dr. Pickett?
Vinny, I thought defense counsel was going to take longer, but the cross-examination was not very long. And so really they were just asking him about his qualifications in looking at children. Let's go ahead and play that testimony.
Did you treat many kids at all?
Not as a general psychiatrist, not as a forensic psychiatrist. As an emergency physician, I frequently treat kids.
And just dealing with, I guess, your role as a forensic psychiatrist in this situation, how many evaluations on adolescents and kids have you done?
As a forensic psychiatrist?
Yes.
Probably my first.
Okay. How many times have you been qualified as an expert to come in and give opinions?
I did have to testify in another case on a patient who was bipolar, and the ex-wife was trying to say just because he has bipolar he couldn't see his kids, and I said he's doing great, he's taking his med, he could see his kid. I was an expert in that. It wasn't, I mean, it was mental health in the legal system, so I think that would qualify, but that's my only other time.
Okay, so this is your first time in a criminal case?
Yes, sir.
Okay. And this is your first time doing an evaluation on a 14-year-old?
I'd like to clarify my last answer. This is my first time testifying in a criminal case. I have done competency evaluations and sanity evaluations for patients regarding criminal cases. I just haven't testified in those cases.
Gotcha. Have you done many evaluations of children and adolescents?
No, sir.
Vinny, during some of his testimony, when he was there on the stand, some of Carly Gregg's family members who sit in the front row of the gallery, they were shaking their head, disagreeing with some of his findings when he was on direct examination. But the courtroom is filled with a lot of her relatives, grandparents, believe her sister, as well as we do believe her biological father, has been in the courtroom as well. And we've often noticed her mouthing things to her grandparents there, saying, "I love you," writing things down on a sheet of paper, and then them reading what she has to say, and always smiling at them when she comes into the courtroom. But I just have to say, it was definitely heavy to listen to the testimony today, hearing all of those words that they were talking, the doctor was talking about in regard to this young 15-year-old girl saying these things about her. You could tell the family members were having a hard time listening to that.
Yeah, and they've been through a lot. They should have a hard time with the killing of Ashley, the shooting and killing of Ashley. There's a lot to process here, but it could be powerful having the family stand behind her, especially when one of those people is one of the victims in the case. So, big day tomorrow, Kelly. Big, big day. It's Friday, closing arguments. We're going to be on a verdict watch or in a verdict. So thank you so much. Kelly Craft in Mississippi. Okay, we're going to bring in our think tank, get their take on what's happening in Mississippi.
Court TV's Vinnie Politan
In every story, in every trial, every case, there's at least two sides to it.
to dive into the latest
Oh my God.
and breaking true crime stories.
This was a very targeted, very personal attack.
Inside
I've never seen that in Discovery. I've been incarcerated 3 years.
and outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinnie Politan investigates tonight, 9/8 Central, only on Court TV.
Based on your experience, expertise, and evaluation of Carlee, do you believe that Carlee was able to understand the nature of her conduct and appreciate the difference between right and wrong at the time this incident occurred on March 19th?
I don't think so.
And based on your experience, expertise, and evaluation of Carlee Gregg, do you believe that she did not know or could not appreciate right from wrong on the afternoon of March 19th?
I do.
And do you believe she understood the nature and quality of this act on March 19th at that time?
No.
My opinion is that Carlee does not meet Mississippi's standard for insanity at the time of the offense, and that she knew the nature, quality, and wrongfulness of her actions during that day.
It's a battle of the experts, and as always, they don't agree. They don't agree. The psychiatrists on either side, they just don't agree with their analysis of what's going on with Carlee Gregg. So let's go through this battle. Let's begin with the defense forensic psychiatrist, Dr. Andrew Clark. Take a listen to his words and remember all the other evidence in the case as well. Let's take a look.
What I think happened on March 19th is the following, that Carlee was, at that point, really in a mental health crisis, that she was having significant mood swings, made worse by the Lexapro, that the voices were getting more and more of a problem for her, that she had documented in a journal entry on March 12th that the voices were very problematic for her, that she was having these dissociative episodes, and that day in particular, she wasn't able to pay attention in school. I take that as a reflection of her worsening psychiatric state. So I really see her as having been in a psychiatric crisis. And then her mother finds out that she's been smoking marijuana. And for Carlee, I think for any teenager, it can feel like the end of the world. I think for Carlee in particular, she so cared about her mother's approval. She's so worried about her mother being worried about her, that for her, this was a crisis. And so an acute dissociative reaction is something that it's a DSM-5 diagnosis that occurs when an individual is triggered by some significant stress and they dissociate. It's not at all uncommon. It is known that people do this, that people engage in violence while in a dissociative state. And there's certain characteristics that are thought to be more likely to make this the real deal dissociation rather than malingering. And those characteristics include a past history of dissociation, a sudden stress, sudden significant stress, often a close relationship with the individual whom you are violent, toward whom you are violent, strong emotional reaction, and no prior planning, no prior threats, and the absence of history of, I guess, criminal or antisocial behavior. So those things are all thought to be consistent with or suggestive of a real dissociative reaction rather than someone just making it up. I think Carly really fits all of them. I think Carly has a much more severe psychiatric illness than anybody realized and that she was able to acknowledge, or even that she's able to acknowledge today. And that combined with her history of dissociation sort of created this terrible situation. I think Carly's understanding is that she doesn't remember, but she thinks that she must have done it. I think that's her understanding. I don't think she has any more insight than that.
Let's bring in our think tank. Joining us tonight, criminal defense attorney, former prosecutor Marie Pereira is with us. Also with us, former criminal defense attorney Kirk Nurmi, and the president of the West Coast Trial Lawyers and former federal prosecutor Nima Rahmani. Great to see everyone. Marie, here's the tricky part for her, right? This triggering event is getting in trouble for smoking pot. Like snagged by mom, according to the expert here, is the triggering event in this mental health breakdown. Little tricky, I think.
Yes, because it creates motive. And I love the way they saved the best for last on the rebuttal, because I do believe that expert explained it in a better way and really made it simple for the jury. What are we looking at here? At the time of this matricide and attempted homicide, was she able to understand right from wrong? Based on the video, yes. She knew enough. She wasn't disassociating. She knew enough to unlock her mom's phone, text her stepfather with Sweetie saying, when are you coming home? She didn't forget any phone numbers. To me, that last expert shut down the defense expert because he really narrowed it down. Did she know right from wrong? Yes, she did. The video can't be denied.
Kirk Nurmi, you know, in a case where you talk about a battle of the experts, the jury may like one over the other, or they may look for other evidence. And that other evidence, as Marie points out, to me is very compelling. The fact that you're hiding the gun from the camera that you know is there.
Yeah, I agree with Marie, and that's why I'd say, Vinny, this is somewhat not what we would call a traditional battle of the experts, because oftentimes when we're making a psychological diagnosis, or somebody is making a psychological diagnosis and presenting it to the jury, is that you don't have evidence of this nature, right? So when we do have evidence of this nature, my thought is, because we're visual, so much of our communication is visual, we're going to, as the jurors, as lay people that they are, they're going to look at this and make their own conclusions. And then I think what they're going to do is they're going to go back to the testimony of the different doctors and use that testimony to kind of support what they see. And I think some of the things Marie honed in on with the texting of the stepfather, the camera, the subterfuge related to the camera, things of that nature are certainly commonsensical. This is what the state's expert did so well, I think. And I think they're going to be able to show that. Now, is she deeply disturbed? Is this deeply troubling young girl? Yes, no doubt about it. But to meet that high bar of insanity, I don't think the defense is going to get there with any of the jurors.
Yeah, and Nima, we always have to remind ourselves and the folks watching, like, you can be mentally ill but not legally insane. They're different. Like, legal insanity is a legal standard. Mental illness is a diagnosis, whatever it is. So even if she's in the midst of some mental breakdown of sorts, it seems from the video, from my perspective, that she still understands I'm doing something that I shouldn't be doing here.
Vinny, we all agree. Me, you, Marie, Kirk, she's not insane. And like everyone has said, it is a high standard. You can't know right from wrong because of a mental disease or defect. You don't understand the nature and consequences of your actions. We're watching this video. This is someone who clearly does. And let's not forget, the burden is on the defense. And I believe in Mississippi, it's a high burden. By clear and convincing, we always talk about reasonable doubt on this show, and as the prosecution met its burden to prove to a jury unanimously that all the elements of the crime have been committed. The defense has to prove this. It's not just a civil standard, it's that higher standard. So I agree. Now, there's the black letter law, which we're talking about, and there's justice. You know, does this young girl deserve 40 years in prison? She clearly has mental health issues. That I'm not certain about, but I do know that she's not insane, and I think the jurors are going to find the same thing.
Yeah, and I think there's two ways to look at that last part, right? One, she's really young, all of that, but she's really dangerous too. So to me, that's the other balance here. It's tragic, but we know what happened here. 2 people were shot. 1 is dead.
Right now, though, we want to get you back to testimony. The jury is watching a police body cam video of when the first officer arrived at the crime scene. Let's go in to watch as well.
Sheriff's office! Sheriff's office! Hey, come outside for a minute. Hey, come here. Hey, where's your wife at, bud? Where's your wife at? She's dead on the floor in that room. She where? Sheriff's office! Hello? That's I need medical here. I need you to go. Hey, where's your son wearing? Hey, can you tell me what your son's wearing? Hey, I need you to talk to me. What is your son wearing?
He was in jeans and a grayish t-shirt. He's got short brownish hair.
So, jeans, a gray t-shirt, short brown hair.
She ran into the backyard. I tried to follow her. She jumped the fence and ran. She shot me in the neck. It's okay.
Does she still have the gun?
It's on the kitchen counter. I think there's one live round left in it. I opened the cylinder. I went in the back door. She tried to shoot me.
Hey, I need some gloves. Hey, he's saying that she ran towards Magnolia Place. Are you sure? He's grazed, but he's considered. It went through his shirt.
You got me right there.
Magnolia Place, that gate is side of injury.
She went over the side back towards my vehicle. She might have looked around this way.
Might look back, going back towards the pond right there. Hey, she does not have the firearm, but the arm is here at the house. Hey, he's been grazed, but he's 22. He didn't really not get She's laying on the floor with a towel. That's all that one system. favor? Will you take that tape right there and just go to those trees, from my car to those trees? Actually, go for the mat box. Did it throw through? Yeah, it went in the front and out the back. It's a 357. Does she have any kind of, what's her name?
Carly Gregg.
Carly Gregg? How old is she?
14. She'll be 15 next month.
Okay.
And work, she's got me work for the door.
She jumped a fence, he said. She didn't go out the back door. Is he the only one? No, we got one. She's in that one. Okay. The back door is locked. She did not go out the back door. Therefore, that's what he's claiming. Gray shirt, blue jeans, short brown hair. Hey, y'all do be advised, there's several firearms in the house. But the one that he's saying was used is laying on the table, but that doesn't mean she's not on it.
We don't know if she's gone.
All right, look to me. You going?
Yeah, I got it.
96 headed to you. There was a white male walking in whenever I was coming in. She's 40 feet.
Body cam video sure does give you a perspective on what happened. You just heard in that video the law enforcement officer saying almost in disbelief, she's 14. Let's squeeze in another break. We're going to see more of that dramatic police body cam video when Court TV Live returns.
Join Court TV's Vinnie Politan.
In every story, in every trial, every case, there's at least two sides to it.
To dive into the latest
Oh my God.
and breaking true crime stories.
This was a very targeted, very personal attack.
Inside
I've never seen that in Discovery. I've been incarcerated 3 years.
and outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinnie Politan investigates tonight, 9/8 Central, only on Court TV.
Let's get you back to court in the deadly daughter murder trial for more of that police body cam video.
Hey, buddy, listen to me, okay? I need to get some information from you. What is her name again?
Carly, C-A-R-L-Y.
C-A-R-L-Y?
Carly Madison Gregg, G-R-E-G-G.
G-R-E-G-G?
She's my stepdaughter.
All right.
Her dad lives in Starkville, and we're having all kind of problems with him. He's
Okay.
drugs and
All right.
stuff.
What is your name, sir?
Smiley.
Edith Smiley?
D.
Okay.
Please get me back to that. All right. Hey.
What's your wife's number? Name?
Ashley Smiley.
All right.
Have you called her? Have you called her? Your wife. I did call her number twice when I ran in there looking for her. And I went in the room.
Hey, how old is Ashley? How old's your wife?
40.
40? I need you to find Ashley Smiley. Ashley Smiley, 40 years of age, white female. Also, I got 27 for the other victims. 801-151-492. Suspect is going to be Carly, C-A-R-L-Y, Madison Gregg. Carly Madison Gregg, G-R-E-G-G. No, you're fine. That's why I was trying to look like. So you're gonna want to see? What? There's all little girls, mother. There's several guns in the house. I need a crime
We're also in a hearing today in Mississippi for 15-year-old Carly Gregg. She's accused of killing her mother and trying to kill her stepfather. He survived. Detectives say that Gregg called a friend after the shooting and invited them over to see her mom's dead body. Gregg is being charged as an adult. This hearing will determine if Gregg is competent to stand trial. Right now, let's head into Mississippi where this is unfolding. The judge is on the bench. Let's get you into court.
On the record, State of Mississippi versus Carly Madison Gregg, calls number 2024-34169. Who do I have here on behalf of the state?
Catherine White Newman, Your Honor.
And on behalf of the defense?
Bridget Todd, Your Honor.
All right. We have the only matters noticed for hearing today are document number 22, a motion for mental evaluation and McNaughton analysis. Document number 23, a motion for issuance of subpoena ducis tecum to youth court. Document number 24, a motion for issuance of subpoena ducis tecum to Blue Cross Blue Shield of Mississippi. And document number 28, a motion for issuance of subpoena ducis tecum to the Rankin County School District. Additionally, while we're here today, the court's going to conduct the Section 223A, subsection 11B, Juvenile Justice Act hearing that's required every 30 days. All right. This was the state's motion. We'll begin with the issuance for subpoenas ducis tecum. All right, let's begin with the document number 23, the motion for issuance of subpoena ducis tecum to the youth court. Is there any objection to that by the defense?
Your Honor, there is no objection to any of the subpoenas by the defense.
All the subpoena ducis tecum, correct?
All the subpoenas ducis tecum were finally being issued.
Do you have copies I can execute today?
I have orders on the school district and Blue Cross Blue Shield. The state would withdraw its motion with regards to the youth court.
All right. Give me the order. Show the second.
Yes, sir. I don't know if we need to give this marker.
We'll give these to the court administrator and get a copy of them from the clerk's office, okay?
Thank you.
All right. State needs to give me an order withdrawing your motion for subpoena ducis tecum to the youth court, please, so we can keep MEC clean. All right? All right. The next matter on the docket is a motion for mental evaluation and McNaughton analysis. All right. Is there an objection to that by the defense?
No, Your Honor, there's not an objection. We just wanted to make sure that that would occur, the state's mental health evaluation would occur after Dr. Webb has finished his mental health evaluation, which should be finished in July.
I can't assure the defense of that. I don't know. So we're on a pretty tight time frame. Tight time frame here. This case is set for trial, I believe, in September. Is that correct?
Yes, Your Honor.
When is Dr. Webb's report going to be finished?
He should be finished with his report by, I want to say, not the 12th, but the Friday after the 12th.
Okay. Has the state already spoken? Looks like you spoke to Dr. Amanda Gugliana.
That's correct, Your Honor, and she's ready to proceed, assuming that our motion is granted as soon as possible, since we know that we have a trial date in September.
Okay. All right, so you have no objections other than the fact you want it to happen after Dr. Webb's analysis, correct?
Yes, Your Honor, and according to Rule 17 of Mississippi Rules of Criminal Procedure, that's technically the way that it should happen is the state puts forward their mental health evaluation or the defense puts forward their mental health evaluation, and then the state can proceed with the mental health evaluation 10 days after we have declared whether or not, our expert has declared whether or not Carly is competent or incompetent for trial. And as of right now, that can't happen. Yes.
Your Honor, I'm not aware of that being in Rule 17. That's about discovery. Rule 12 is what talks about mental evaluations, and the state is not aware of anything in the rule which requires it to wait until after the defendant has completed its evaluation.
All right, well, let's do this. The only issue that we're in disagreement on is the timing of it. It's the state's motion. I'll let the state argue, then I'll let the defense argue, I'll let the state reply, I'll rule, and we'll be finished. All right? So, can you step to the podium, step to the podium. Ms. Newman, I'll hear what you got to say.
Aaron, the state filed a motion for mental evaluation and McNaughton analysis on June the 17th of this year. Pursuant to the case law cited in that motion, as well as Rule 12, which governs mental evaluations in criminal matters, either party or the court on their own can request that an evaluation be done if there's reasonable grounds to believe that such evaluation should take place. Pursuant to the defendant stating multiple times that they had hired a private evaluator, Dr. Mark Webb, to conduct an evaluation, the state believes that the insanity defense has not properly been alleged, but believe that upon information and belief based on their arguments regarding Dr. Webb, that that's what the defendant intends to introduce as some sort of insanity defense. The state is not required to sit back and wait for them to produce a report claiming that she's insane before funds can be acquired and evaluation can be started on behalf of the state. In fact, the case law talks about once doubt is raised as to someone's competence or insanity, the state bears the burden to prove that they are in fact competent and they are in fact sane. And so the state should not be required to rely on a report by Dr. Webb, who is a private evaluator paid by the defendant, before we are able to have the defendant evaluated. Specifically, we have gone ahead and contacted Dr. Amanda Gugliano, who is one of the psychologists who is certified to complete such evaluations through the Mississippi Department of Mental Health. As the court's aware, the way that the evaluations are conducted back in November of last year changed. And so there's two options for the state of Mississippi. We can go through the state hospital and have them assign someone, or we can go ahead and select someone and contract with them directly. We've chosen that option in order to streamline the mental evaluation. Our trial date is quickly coming upon us. There's nothing to require Dr. Webb to complete his evaluation by the date that counsel has stated in July. There's no guarantee that that will happen. Again, the state's not required to wait until he does that. They've offered no response to our motion. They filed no response. They provided no case law or cited to any statute or law that requires that we wait until after their evaluation is conducted. In fact, the state also, prior to coming to circuit court, tried to agree to a mental evaluation on behalf of the defendant. There was communications back and forth where the state said we would not wait indefinitely in order to have this done. We did not want to have, so to speak, them to drag their feet and say, well, we'll agree to it, but we'll sign it when we want to. I spoke with counsel, Mr. Kevin Camp. He's not in the courtroom today, but I feel certain that he would agree with me that I told him that we would have agreed to an evaluation. However, there was a deadline put on that so that this case would not sit unindicted and without a mental evaluation. Excuse me. Pursuant to our motion, we do ask that the defendant be evaluated both for competency to stand trial as well as a McNaughton analysis. Again, to streamline things, we prefer that it be done at the same time rather than one and then ordering that the other be done subsequent to that. We've asked that any medical, psychiatric, psychological, educational, addiction, or employment records and privilege be waived so that Dr. Gugliano can achieve her evaluation and she can get any records that are necessary, which is also why we filed our motions for subpoena ducis tecum that the defense did not object to in order to get her school records and Blue Cross Blue Shield medical and pharmaceutical records so that we know each and every provider that she saw. The state is again asking that our motion be granted and that we be allowed to use Dr. Gugliano to have this defendant evaluated as soon as possible rather than having to wait until after Dr. Mark Webb is complete with his analysis. Thank you, Your Honor.
Response by the defense.
Yes, Your Honor. Your Honor, Rule 17.4 of the Mississippi Rules of Criminal Procedure states that
there is a lot to unpack here. So the best person to do that, let's bring in our guest watching along with you at home. In Los Angeles, California, friend of the program, we have Marie Pereira. You're a former prosecutor, defense attorney. You're also a registered nurse. The list goes on. First thing that's going through my mind is how common is it to have a teenager as a defendant accused of killing their parent, their mom?
extremely uncommon, and it's extremely sad too. And frankly, I don't understand why the defense is arguing with prosecution if they want to go ahead and try to evaluate her for possible insanity under the McNaughton rule. It is what it is. What happened here clearly to me says this person was not mentally well and sound, that she murdered her mom, waited for her stepdad to come home to out him too, while all the time playing with her dog and inviting her friend to come and watch. If that's not insane mental disease, making a person incapable of understanding right from wrong, I don't know what else is. And they should allow any testing that needs to be done pre-trial in order to get to the bottom of why this little girl did what she did.
Yeah, and you know, she was only 14 at the time of that alleged brutal attack against her mom and her stepfather, her mom losing her life. So many questions for you, Marie Pereira, about what they have to prove, but we're going to put a pin in it because right now we have to fit in a short break. We're going to be talking about this case much more and bring you back into that courtroom in Mississippi when we return. You're watching Court TV Live, your front row seat to justice.
Tonight on Court TV.
These are the big cases that everyone is talking about.
A lot of new developments taking place.
Shocking.
I know who killed John Bonet.
To say the least.
You cannot make this stuff up.
It's unreal. The scene of the double murders is behind us right here. Things are happening. The investigation is continuing.
Closing arguments with Vinnie Politan. Tonight at 8, 7 Central. Only on Court TV.
And welcome back to Court TV Live. I'm Matt Johnson in Dedham, Massachusetts, just outside of Boston. And today we are in Mississippi and we are following a really important hearing involving a teenage girl accused of murdering her mother. Well, she is in court right now for a competency hearing. Prosecutors say the 15-year-old girl, Carly Gregg, was 14 at the time of the shooting. She killed her mother, Ashley Smiley, according to prosecutors, and then waited around to shoot her stepfather, Heath Smiley. He survived with a gunshot wound to the shoulder. Let's get you back into court right now.
Your Honor, Rule 17.4 of the Mississippi Rules of Criminal Procedure states that if a defendant intends to introduce expert testimony relating to mental illness, defect, or other condition bearing upon the issue of whether the defendant had the mental state required for the offense charged, the defendant shall, within the time provided for filing pretrial motions or at such time as the court may direct, serve upon the prosecuting attorney, the clerk of court, notice of such intentions with the names and addresses of such expert witnesses upon which the defense intends to rely. The prosecuting attorney shall serve a notice on the defendant promptly, but in no event less than 10 days prior to trial, stating the names and addresses of any witnesses whom the state intends to rely upon relating to the issue of the defendant's mental condition at the time alleged. The way it is intended, and even the notes under that, talks about the defendant raises it, puts forth their expert opinion, then the prosecutor can rebut if it is found that the defendant has found that they're going to rely upon that. However, at this point, we don't know if we can rely upon that because our expert has not finished his mental health evaluation. Dr. Webb is very reliable, very good at his job, but it takes time. And in this situation, we had a child who is being charged as an adult, but who nevertheless is being kept in a solitary confinement 23 hours a day in an adult facility where he then goes to see her. And also, immediately after she was arrested and detained, she was placed on various medications, one being Abilify, which was an antipsychotic by a nurse practitioner. So there have been medication issues too that Dr. Webb has had to wait to weigh and see what, if any, effects those were having on her. And that's just why it's taking a little time. But like I said, he is due to be done, and we are able to produce his mental health evaluation the Friday after July 12th. I'm not sure how long the state's expert will need or what testing will be involved, but that's well in advance of the September trial date.
Anything further?
No, Your Honor.
Your Honor, again, 17.4, sorry. Rule 17.4 comes into play once the defendant has filed a written notice. The defendant has not filed any type of written notice in front of this court. The state, however, has provided written notice that we intend to solicit the testimony of Dr. Amanda Gugliano, who is a certified psychologist who would do the testing on the defendant regarding any insanity and or competency. We believe at a minimum she should be able to get started on her competency evaluation with regards to this defendant. Again, there's been no written notice provided by the defendant to put Rule 17.4 into play. With regards to the medication that the defendant may or may not be on, again, if the defense attorney would look back, they would see that the state actually agreed to have her assessed by Region 8 in the beginning, and it was our intention that she be assessed by the Mississippi State Hospital at that point. However, the orders merely provided that she be assessed by Region 8 for evaluation and treatment. We've been asking since the beginning that she be evaluated, and we believe that it would be in both sides' best interest in order for judicial economy in this trial not to be continued if our evaluator would be able to proceed with her evaluation as soon as possible. Thank you, Your Honor.
All right. Court, having heard arguments from both sides, the court is not concerned with the particular written notice. The court's relying mostly on Ballard versus State of Oktibbeha County. The entire purpose of the notice requirement is to prevent trial by ambush for either side. Neither side should be surprised at trial. While I understand the rule says not more than 10 days, it also says unless otherwise ordered by the court. Y'all are both on notice, y'all are otherwise ordered by this court. We're not going to wait till 10 days before the trial to release all of our information. All right, while the court would prefer for Dr. Webb's report to be complete, I believe this court's experience with mental evaluations is they're normally done in multi-stage on multiple dates. So for that reason, the court's going to grant the state's motion for mental evaluation and McNaughton analysis. The court is not going to limit it until after the release of Dr. Webb's report. However, I do believe, from a practical matter, Ms. Gugliano is somewhat hamstrung until she gets Dr. Webb's report. Dr. Webb's report comes back and says that, hey, there is no McNaughton issue here. We'll double back and we'll deal with that. Okay. But what the court doesn't want to do is delay this case. As defense counsel said, she is this court revoked her bail. She is being held without bail, so I intend for this trial to go forward in September. All right, for those reasons, the court will grant the motion for mental evaluation. All right, now, as to the Section 223A, subsection 11B of the Juvenile Justice and Delinquency Prevention Act concerning juveniles charged as adults. All right, state have anything it wishes to add on the juvenile justice hearing?
No, sir, Your Honor.
Anything from the defense?
No, Your Honor. Other than there was an incident where an adult inmate who was being housed in the same pod area as Carly was making threats to harm and physically assault Carly, but Carly was able to tell her grandparents, who were able to tell me, and I was able to get someone from the detention center on the phone to handle it.
Mr. Chandler, is she being housed in the general population? No?
She's isolated, sir.
She's isolated. All right. I don't tell the sheriff how to run his jail, but I believe our sheriff has enough good sense not to put this young lady out in the general population at this time. Court looks at the following factors. Age of the juvenile, she's 15 years old. Physical and mental maturity of the juvenile. The court heard at previous hearings she's a very intelligent juvenile. Present mental state of the juvenile, including whether or not the juvenile represents a risk of self-harm. There was prior testimony regarding self-harm of this particular juvenile while she was not incarcerated. However, the court's heard of no such danger while she is incarcerated. Nature and circumstances of the alleged offense do not weigh in favor of the defendant. The juvenile's history of prior delinquent acts. I believe the state court doesn't have anything in front of it yet. The state's moved for a subpoena ducis tecum that may shed more light on that. You said you have information that she's...
Yes, sir, Your Honor. Upon information and belief, the defendant was brought some contraband, possibly a knife, to school and was sent to the Learning Center back in September of 2021.
All right. The relative ability of available adult and juvenile detention facilities. Court would know, I worked all over the state of Mississippi. I think that the Rankin County Detention Center is jokingly referred to as the Hilton of jails throughout the state of Mississippi. Rankin County Sheriff's Department runs a very safe jail. For those reasons, the court will not have any change to the juvenile justice detention that she's currently maintained under. Anything further from the state?
None from the state, Your Honor.
Anything further from the defense?
No, Your Honor.
We'll be in recess. Best of luck to both sides.
And it seems like it's not over for that defendant as the judge is going to be making his decision. Let's bring in our guest to discuss this. Still with us, criminal defense attorney, former prosecutor, joining us from Los Angeles, California. We have Marie Pereira. Marie, my question to you, competency. How is that determined? What do they need to prove or not prove?
They need to prove that because of her mental disease, she was incapable of understanding legally and morally right from wrong. So she didn't really understand shooting someone in the chin, in the face, attempting to kill somebody was not legal and it's not moral because she is suffering from mental disease and could not wrap her head around the fact that something like that is wrong. That negates intent. To have intent, you have to have a mind to create that intent. No mens rea when you're insane. And I think this child had a history of mental disease even before this happened. She was on medication. When you look at her, she doesn't even look like a 15-year-old. She looks even younger than that. She needed to be evaluated, and I agree with the judge that they're granting the state's motion even before defense completes their evaluation because clearly we're looking for justice, and I think part of the justice is to evaluate this child's mental status.
Yeah, but our system also is a system of rehabilitation where possible. When you have a defendant that is 14, now 15, not even at the trial phase yet, the innocence guilt, what is this child looking at? Life behind bars, potentially, if convicted?
No,
or is there a possibility of getting out on the street?
There is a possibility. If they deem her not guilty by reason of insanity, she's committed to a mental institution, at which point she will get treatment and doctors will evaluate her throughout her lifespan in that facility to see, is she safe to leave now? Is she a danger to herself? Is she a danger to the community? It is not a forever sentence. It's until such a time that experts treat her and see what's going on in her mind.
Sign all those. Okay. All right, we're on the record in 24-15875, the state of Mississippi versus Carly Madison Gregg. We have several things that we need to discuss concerning Ms. Gregg today, that we have to cover with Ms. Gregg today. You're Mr. Coleman. Sit down, Mr. Coleman. You're going to be a minute. First thing I want to cover, and you can speak to me from seating right there, Mr. Coleman, is MEC 49 and MEC 50 as it relates to Ms. Gregg, or the orders for mental evaluation. Have you had a chance to review those?
No, sir, we have not. But our retained medical doctors have informed us that they are unable to complete their mental evaluations and testing until Carly is released from jail.
All right, well, that's not going to be necessarily true. All right, so here's the way we can do that. And I understand that that's one of the concerns, and it's certainly a concern, but we got two different things going on here. So I'm going to address what you said first, then I'm going to come back to the Mississippi State Hospital. She can be either evaluated in the jail, or if your psychiatrist or psychologist believes that she needs to come to his office, she can be transported by the court staff and deputy to his office for any evaluations. So her detention or incarceration will not prevent her from being evaluated. So if you're sincere about wanting her evaluated by someone of your own choosing, then you need to make yourself available for that, because as they say, the dog won't hunt going forward, because we will accommodate her being evaluated by your expert. Now, the second thing is the orders MEC 49 and 50. I want you to go back and look at those today, because both of those, MEC 49 is the order for mental evaluation for competence to stand trial. And the second page of that order specifically requires the defense counsel to promptly prepare and furnish to the examining mental health expert the following. Now, I understand he hadn't had a chance, and I understand you don't have a report, but there are other things there that you can provide to the mental health facility at the Mississippi State Hospital. And then once you do that, you're required by order of the court to file a certificate of compliance that you have done that. So both MEC 49 for the competence to stand trial and MEC 50, the supplemental order for McNaughton analysis, both have affirmative requirements for the defense counsel to provide information to the state hospital and to file certificates of completion. The state hospital can't begin until you've done that. The state of Mississippi has already done that. They've sent their material there, they filed their certificate. Is there any reason, Mr. Coleman, that you can't get this filed in the next 24 hours?
I would have to speak to Carly's medical examiners, Your Honor. I'm not aware of their schedules. I'm not aware of their availability. Certainly, I'm willing to reach out to them and see if we can expedite that process.
All right, my patience is going to be a little thin, Mr. Coleman. The order says 10 business days from the date of the order. April the 18th was when the order was entered. So we've run out of 10 business days since the entry of the order, and this is obviously a most serious event. And while you certainly have a right to have a mental evaluation done, the state of Mississippi has a right to have the state hospital perform one as well. And I'm not going to allow you to obstruct that process. I'm not accusing you of obstruction. I'm just telling you right now we have non-compliance with my orders, all right? Today's Tuesday. I'm going to review this next Tuesday, Mr. Coleman, and I expect when I pull up MEC to find certificate of compliance for both MEC 49 and MEC 50 that says that to the best of your ability you have complied with the orders of this court. Now, if you have not provided those by next Tuesday, then I'm most going to be dead up honest with you, and we'll have a show cause hearing. I'm serious as I can be about this. This is a serious matter. I need your cooperation. I will have your cooperation, whether you cooperate or I have to make you. I'm not trying to be ugly. I'm just trying to tell you how serious this is, okay?
Understood, Your Honor.
Okay. All right. That's fair enough. All right. Now then, let's move on to the two motions that the defense has filed. We got two items on the agenda, the docket today. One is MEC 53, which is a motion to reduce bond filed by the defendants on this past Friday, May 10th. That was MEC 53, and a motion to exclude the public and the media, which is MEC 56. According to the Mississippi Rules of Criminal Procedure 1.3D, it states that a written motion and notice of the hearing thereof shall be served no later than 5 days before the time fixed for the hearing. The notice of hearing for both motions was today. The motion to exclude the public and the media was filed yesterday, the 13th. We clearly are not within the, we've not had the requisite time here. Mississippi Rules of Criminal Procedure 1.3A specify that when the period of time prescribed or allowed is less than 7 days, which is what we have here, that Saturdays and Sundays don't count. So we don't count the day of the filing, but if I did count the day of the filing for MEC 53, which is the motion to reduce bond, then we've only got 3 days. If I count the day of filing yesterday, which I'm not supposed to, but if I did, for the motion to deny access to the public or the press, then I've got 1 day on that clock. So, all that to be said, Mr. Coleman, the rules of criminal procedure have not been followed as it relates to notice on those two motions. That can be cured by the state of Mississippi if they choose to waive time in this event. Mr. Berry, what's the state's position on these two motions?
Your Honor, as to the motion to reduce bond, I spoke to Mr. Coleman beforehand and tried to talk to him about that, and the state does not choose to waive that at this point. And generally, when we choose not to waive that at this point, it's motion to exclude the media and the public. Your Honor, we defer to the court on that, as for this motion.
Okay. Well, and I tell people all the time that it's a lot easier for me if I just follow the rules. And they're, like everything else, we have a lot of rules as it relates to criminal process. And I've just been quoting the rules of criminal procedure as they relate to motions and notice. But also there is a set of rules, oddly enough, for the Mississippi Rules for Electronic and Photographic Coverage of Judicial Proceedings, which our media does a good job of complying with. I've not had any objections or any complaints regarding the media whose willingness or want to be here. They do provide their notice as they are required. I honestly believe that the public has a right to know this is a public forum. These are public courtrooms, barring specific problems, and I'm not ruling on the motion because the state's not waiving time, so it's not properly before me. But I just say that, I say all that to say that the rules for electronic and photographic coverage of judicial proceedings, Rule 7, which the defense has complied with, says any party may object to electronic coverage by written motion, which the defense has done, which was filed yesterday. And it says such motion shall be filed no later than 15 days prior to commencement of the judicial proceedings unless good cause exists to shorten the time for filing. So what we'll do, I know the media is an interested party here as well, who would probably object to any closing of any judicial proceedings as it relates to Ms. Gregg. So the rule requires at least 15 days out there. So we can do it, Mr. Coleman, however you want to. You got two motions. The motion to exclude the media, I won't hear until 2 weeks from today. I'm going to give them 15 days and get what the rule says. The second one, the motion to reduce bond, you will certainly have met that time requirement by next Tuesday. So it really, if you want to hear it, the motion to deny bond next Tuesday, it kind of renders your other motion moot, because we will not have heard the motion to exclude the public and the media. Now, if you want me to hear that one first, then I'm going to need to hear both of them 2 weeks from today. So what's your choice?
Understood. Your Honor, we believe that the media should be excluded. We believe that Carly's being prejudiced by the media. We believe that it's in her best interest to exclude them first, potentially, and then have our bond hearing.
Fair enough. Fair enough.
But one more thing, Your Honor, I understand that the rules are the rules, but Carly is also entitled to a bond hearing every 30 days, correct?
Well, she's had one, and she's entitled to bond. And I'm going to be pretty open about those things. Whether something has. And my first thought was when I saw your motion file, my first thought was, what's different? And it won't do any good to come back. And I know you didn't argue the previous motion, but if there's not any new information, we're kind of wasting everybody's time. So I assume that when you bring forth a new motion, and I'm not going to restrict you, Mr. Coleman, on, we can hear it as many times as you want to present them if we have new information. Now, we're not going to beat the dead horse if, nothing new has happened since the last hearing. But I'm open. The bottom line is I'm open to hearing any motion you have. So I hear what you're saying on the motion to exclude the media and the press first. So what we'll do is we'll continue both these motions to 2 weeks from today. We will hear the motion to exclude the media and the press first. Then I will rule on that, and then we'll deal with the motion to deny bond. I will tell you, though, Mr. Coleman, that the default position, of course, by the Supreme Court is to favor the media and the public. That's the default position. Momentum begins against you in that event, so you'll need to make a compelling argument for the court to determine that the public and or the media is not entitled to participate or to observe the proceedings as they relate to Ms. Gregg. So anything else at this point, Mr. Coleman?
No, Your Honor.
Mr. Berry?
No, sir, Your Honor.
Okay. All right. And Mr. Coleman is, I know, I want to point out a couple things further, just so everybody knows. I know the case with Ms. Gregg has generated a lot of attention, but I want to, and I know being a juvenile creates more attention here, and I am sensitive to that. And I know the last time we were here, the family had an opportunity to visit with Ms. Gregg. I'll extend the same opportunity again, family. If y'all want to visit with Ms. Gregg, we'll do the same thing we did last time. Just go back to the jail and they will accommodate you there. It's also my understanding that Ms. Gregg has access to an electronic pad that she's able to make phone calls with, FaceTime with. There are no restrictions on her use of that pad. I understand that they have a time limit of 15 minutes per call, but I understand that once you time out on that call, she can place an immediate call right behind that. So it's my understanding that she's either, as of yesterday, I think she had used that pad 36 or 37 times and had one physical visit. So I am sensitive to what's going on here, but I do know that we try to accommodate her and the other juveniles with access to these communication pads so that she can communicate with her family. All that being said, we'll go ahead and pause this hearing now. We'll take a short recess to let me swap out defendants here for a moment and return Ms. Gregg. And family, if y'all want to make your way back to the jail, then you'll be able to visit with Ms. Gregg at that point. All right, we'll be in recess for about 10 minutes. Okay. Okay. Well, just tell me. Yeah, I got it. Okay. Okay.
Mr. Coleman?
Mr. Clerk, would you sound the docket, please?
2024 KA 1178 SCT Carly Madison Gregg versus the State of Mississippi.
What says the appellant? What says the state? We'll hear from you.
Good morning. Justices, may it please the court. My name is James Murphy, and it is my honor and it is my privilege to be here on behalf of Carly Madison Gregg. Here at co-counsel table with me is Lance Mixon, and we're both honored to be here as appellate counsel for Ms. Gregg. Now, this case is ultimately about whether a 14-year-old child received the fundamentally fair process the Constitution of the United States and the Constitution of the State of Mississippi requires before a juvenile can be sentenced to the most severe punishment, given the harshest sentence that the State of Mississippi can impose on a juvenile, and that is life without the possibility of parole.
Counselor, let me stop you there. I've read the sentencing order. The sentencing order in this case says that she's been sentenced to life imprisonment, which under the statute, and I think this is consistent with the argument you make on the sentencing issue, the statute, in subsection 2 of the sentencing statute for first-degree murder, gives two options. The jury can do life, can give life imprisonment, and if the jury doesn't, then the judge can assign a term of years. I don't know that I agree with you that this is a life without the possibility of parole sentence. The sentencing statute in subsection 3 seems to say there's life imprisonment. It doesn't seem to say, it does say there's life imprisonment, and then there's life without the possibility of parole or a term of years. So I'm reading this sentencing order, and to me, it's life imprisonment, not life without the possibility of parole. So why do you take the position that the sentencing order, what the sentencing order says is not what the sentence is?
Well, we would agree with Your Honor on that point, and if the state would concede that, I think we could make an easy argument of our sentencing argument here today. But I think the state's position is going to be that that life sentence that was imposed by virtue of the parole statute imposes life without the possibility of parole. The jury in this case was given a sentencing instruction that gave them the option of sentencing Carly to life imprisonment or life with the possibility of parole. Now, by virtue of those two options, if they're not giving her life with the possibility of parole, by giving her life imprisonment, they are giving her life without parole. Those are just mutually exclusive options.
Well, I understand there's a separate parole statute in play here, and I can't remember the style of the case, but I know this court's issued an opinion that addresses the interplay between that parole statute and life sentences in other contexts. But just strictly speaking, or leaving the application of the parole statute out for a second, there are two options in that sentencing statute: life imprisonment and a term of years, and this sentencing order says a life imprisonment. So I don't see an inconsistency between the sentencing order or the legal sentences under the statute. And since that statute doesn't mention life without the possibility of parole as a legal sentence for this crime, I'm right where I am. I'm struggling to see why this is being interpreted as a life, other than the jury instruction, which admittedly doesn't match the sentence. But what we have in front of us, which is the order of the court sentencing Ms. Gregg, this is a life imprisonment sentence, which is consistent with the statute and doesn't seem to be without the possibility of parole.
And we would, yes, Your Honor, we would agree with Your Honor's interpretation of that. And again, if the state would concede that, we would certainly move on from that argument. But the state has argued in their response to our brief that by virtue of the parole statute, that life imprisonment judgment is in effect a life without the possibility of parole. And as I'm sure Your Honor and the court is aware, the legislature amended the first-degree murder sentencing statute 97-321, amended that statute effective July 1st, 2024, and added a juvenile-specific sentencing structure for both first-degree murder and capital murder. And subsection 2C, which deals with capital murder for juvenile convicted of capital murder after July 1st, 2024, it gives the jury two options, as I think Your Honor would concede. It gives the jury the option of sentencing a convicted juvenile to either life imprisonment or life without the possibility of parole. However, subsection 2B omits that option and only gives the jury the one option of life imprisonment. And I think that goes along with what Your Honor is saying. The first-degree murder sentencing options for a jury in a juvenile case only gives the jury the option of sentencing a juvenile to life. And by virtue of the legislature defining life without, or including life without parole in subsection 2C, and not defining life as life with parole, the only other option is that life imprisonment means life with the possibility of parole. So we would concede, Your Honor, that is the case. In fact, if the court interprets the amendments that way, we would concede that argument. But from March 19th, 2024, when the incident occurred, until the verdict and sentencing order were rendered on September 20th of 2024, this entire case, the entire case, from investigation to indictment to psychiatric litigation to motions filed to motions argued to expert evaluations to discovery to trial to sentencing, it proceeded in approximately 6 months, 183 days to be precise. In a medically and psychotropic medication evidence and dissociation case of this nature, that pace was extraordinary. And the accelerated pace of the proceedings affected virtually every aspect and major issue now before this court. And my first issue I was going to begin with was the sentencing issue, but as the court, I think we've discussed that. If there are any additional questions about that, we would argue certainly that the amended statute does not give a jury the option of sentencing a juvenile convicted of first-degree murder after July 1st, 2024. We would argue that the new amendments do not give a jury the option of sentencing, nor does a judge have the option of sentencing a juvenile convicted of first-degree murder, does not give them the option of sentencing her to life without parole. Now I will transition to the Miller issues. Again, we would argue that the new amendments, they pretty much make Miller obsolete in the context of sentencing a juvenile after the amendments. But assuming that the Miller progeny of cases is still in effect and is still the controlling law when it comes to determining what's proper sentence for a juvenile convicted of first-degree murder, we would propose that the Miller framework was not met in this case. The Miller requires individualized sentencing before a child may be condemned to die in prison. And again, we're operating under the assumption that the state's position is that Carly Gregg was sentenced to life without the possibility of parole. The proceedings here never became the careful, individualized juvenile sentencing hearing contemplated by Miller. The sentencing phase of this case, and again, this case went from the occurrence of the event on March 19, 2024 to the trial on September 16th, concluding on September the 20th of 2024. The sentencing phase, and I'm going to use that term loosely, the sentencing phase of this case consisted of the court announcing the verdict of the jury and then transitioning immediately to asking the state whether they wanted to call their first sentencing witness, to which the state responded that they basically wanted to rest on the evidence that had been previously presented and proceed with argument only. And the defense did the same thing. The defense elected to rest on the evidence that had been previously presented and proceed with argument only. Now, we would argue that this immediate pivot from the announcement of the verdict to the sentencing phase was wholly inadequate in light of Miller. There was no meaningful mitigation development process. There was no opportunity given to the defense to marshal mitigation witnesses. They were given no opportunity to call witnesses, family members, teachers, and as a matter of fact, as part of the pretrial process, the defense listed as one of the potential witnesses the grandmother of Carly Gregg, Miss Vicki Breland, who also happened to be the mother of one of the victims, Ashley Smiley. She was listed as a potential witness, and she was not allowed to testify at the trial. So it stands to reason if she was not allowed to testify at trial, then the question then becomes, would she have been allowed to testify during the sentencing phase? And again, I use that term loosely because there was no meaningful opportunity to conduct a Miller-compliant sentencing hearing. There was no PSI, pre-sentencing investigation conducted, no report. The jury was exposed to confusing and inconsistent parole rhetoric by the prosecution at one point. And again, I'm going back to the sentencing hearing, which consisted of, and it's confusing, the record is confusing as to whether each side was given 7.5 minutes, 15 minutes total for their sentencing argument, or whether they were each given 15 minutes. At one point, it looks like the judge gave one side 7.5 minutes, and then the other side was given 15 minutes. So it's not clear to me from the record whether they were given 7.5 minutes to argue the sentencing phase or 15 minutes to argue the sentencing phase. But at one point during the state's argument during the sentencing phase, the state told the jury that if you give her, and again, this is going to the sentencing instruction that they were given the option of life or life with the possibility of parole. The prosecutor stood in front of the jury and told them that if you give her life with the possibility of parole, we don't know when she's going to get out. She might be out, and I'm paraphrasing here, she may be out in as little as a year, which I think we all know is outside the realm of possibility for a life sentence. But she may be out in as little as a year, and again, I'm paraphrasing, but you may see her at the supermarket, or you may see her at church. You may run into her at any place outside in public, and again, we would argue, and we argued in our brief, that that is improper golden rule rhetoric. It's appealing to the fears of the community, and that is improper. And I understand the state's going to argue and has argued in their brief that the defense failed to object to this, but notwithstanding that failure, we would ask this court to analyze that under the plain error doctrine and or pursuant to the ineffective assistance of counsel claims that we've made in our brief. We can see no strategic reason why a competent defense counsel would not object to that type of rhetoric argued in a sentencing phase. And in addition, even taking into consideration if the Miller progeny of cases is still the law and still applicable to juvenile first-degree murder and capital murder cases, the record is replete with examples of why there were mitigating factors. And we would submit that the juries, and again, assuming they sentenced her, they elected to sentence her to life without parole. And by the way, let me back up, I digress just a little bit. After the prosecution's statements about parole eligibility and when she might be out within a year, and you might run into her at the supermarket, after the jury began their deliberations, almost immediately after they began their deliberations, we know that parole was on their mind and how long she's going to spend in jail if she gets granted parole eligibility, because they submitted a question, and I'm going to paraphrase this too, if Carly is granted parole eligibility, if she's given life with the possibility of parole, which is one of the two options she was given by the court, if she's given life with the possibility of parole, how long will she serve years-wise? So we know that was on their mind. We absolutely know that was a question that they had in their mind going into deliberations. Nothing minimizes the horror of what happened to Ashley Smiley or the trauma suffered by Heath Smiley. Nothing minimizes that. But Miller requires courts to distinguish between irreparable corruption, incorrigible youth, and transient immaturity before condemning a child to die in prison. And again, assuming that the state's position is correct, that she was sentenced to life without possibility of parole, that is exactly what she was done. She was sentenced to die in prison, because if she's not eligible for parole at any point, then she will pass away in prison, and that's in effect a death sentence. And I want to read
Mr. Murphy,
from a brief.
Mr. Murphy,
Yes,
let me
Your
just interrupt you there for a second. I want to clarify something for purposes of I know this court has written that for purposes of the application of that parole statute, the one that forbids parole for people guilty of first-degree murder, we have held in the Miller context that is the same as a life imprisonment. So, but you've still got, I think you conceded, not just as to those comments that were made by the prosecutor, but also as to the hearing itself and the brevity of the hearing, et cetera. There were no objections made by defense counsel that would have preserved that issue for appeal, were there?
No, Your Honor, there were no objections. And as to that issue, Your Honor, a case that we cited in our brief, Presley v. State, which is 474 Southern 2nd 612, a case that was decided by this court in 1985, a case where the sentence was vacated, and in that case, a pre-sentence investigation report had been prepared and submitted to the court. The trial court offered defense counsel the same as apparently the trial court did in this case, gave defense counsel the opportunity to present mitigation, and defense counsel nevertheless failed to meaningfully develop mitigation evidence. And the court in that case vacated that sentence based on the rationale and the holding that, and I'm going to quote from the Presley court, we recognize that there are cases even where the appellant and his attorney fail to prepare and complete a sentencing record, as was done in this case, or not done as the case may be, where the trial court must consider all facets, background, and record in a sentencing hearing in order that a just and proper sentence may be imposed. So we would submit to Your Honors that this court has the power to impose that duty on the trial court just as it would impose the duty on the defense counsel. And even barring that plain error submission that we are offering here today to give the court the authority to review that, again, I think we've offered the Strickland v. Washington ineffective assistance of counsel claim. We can fathom no strategic reason why defense counsel would not want to ask for time.
Is this court in a position on this record to evaluate the prejudice prong of Strickland, not knowing what mitigation evidence might have been discovered had that work been allowed to proceed?
I believe that we could evaluate the prejudice prong based on what we know about what had been presented earlier in the case. We had two forensic psychiatrists who testified in this case. And I believe even the state's forensic psychiatrist opined that Carly was not a psychopath, that she was not evil, and that she came close, and I'm paraphrasing here, that she came close to the evaluation needed to reach the McNaughton standard. Even the state's own psychiatrist stated as such. And then you had the defense psychiatrist who found that she did meet the McNaughton standard. So the failure of the defense counsel to at least recall those witnesses to testify in the context of a sentencing phase would clearly be prejudicial. To bring out those points that they had made earlier in the proceedings to specifically apply to the sentencing phase, I believe that's absolutely prejudicial, Your Honor. In addition, the issues that I brought up earlier, the witnesses, the lay witnesses that could have been marshaled and provided, the family members that I believe are here today and that were prepared to testify on behalf of Carly in the sentencing phase, teachers, friends, all of those things, as far as we are aware and as far as the record reflects, they would have all testified on behalf of Carly and would have provided positive mitigation evidence on her behalf. So yes, Your Honor, we would submit that the record is sufficient to evaluate the prejudice prong of the Strickland analysis. Now, outside of the sentencing issues that we've discussed, Your Honor, the trial court announced at the very first interaction between the trial court and the litigants in this case, announced not once, but twice, that this court does not continue cases. And it even mentioned that y'all have heard me say this before today, that this court does not continue cases. Now, that posture shaped the atmosphere of the litigation from the very beginning. Now, you may ask, is that in and of itself, is that an abuse of discretion? And we would offer, and we cited Leonard v. Leonard, where a discussion was had of whether a court can issue blanket denials of continuances, and that court held that it is abuse of discretion to prejudge and pre-rule that there are no continuances allowed under any circumstances. And that we would submit that is exactly what the trial court did in this case, announced from the outset that there are no continuances going to be granted. Now, the state offered in their response brief that this was not a blanket denial of continuances. This was just an attempt by the trial court to prevent dilatory tactics of the litigants. But, Your Honor, looking at the four corners of the transcripts, we saw no caveats issued. There were no continuances unless so-and-so happens. No continuances unless there's a darn good reason. There was none of that. It was a blanket denial of continuances. Well, then the state's going to submit to the court. Well, the defense never asked for a continuance. So there's no harm, no foul. It's harmless error. Even if it's error for the court to issue a blanket denial of continuances, that error is harmless. But to that, Your Honor, we would offer a plethora of cases, including Mississippi Rule of Evidence 103C, that says no further objection or offer of proof is required where the court's ruling is definitive. Smith v. State, which we cited, 724 Southern 2nd 280, preservation rules do not require actions that would serve no practical purpose.
Mr. Murphy, without any motion being filed, exactly what do we have in the record where we could say that it was an abuse of discretion not to grant a motion for continuance?
Well, it was not necessarily an abuse of discretion to not grant a motion for continuance because obviously, as we would concede, there were no motions for continuance.
But I mean, are there any reasons for a continuance? I haven't even heard you argue whether there were any reasons for a continuance that were considered, contemplated, and not requested. You're just simply asking, as a statement of law, for us to find the trial judge in error because he made a statement.
Well, Your Honor, and again, going back to this line of cases that basically says a litigant, a defense attorney, or any attorney is not required to ask for something he knows he's not going to get in order to preserve error. That's exactly what Mississippi Rule of Evidence 103C says. Further objection or offer of proof required where the court's ruling is definitive. There is no requirement.
Counselor, further objection seems to indicate that there was an objection initially. So I think those cases that you're citing, in those cases and the text of that rule, still seem to require an initial objection or motion that is denied. I know that Leonard versus Leonard, there was a motion that was denied. That's what the court was reviewing for error, was the decision. So, I mean.
And I think the rules of civil, at least the rules of civil procedure, required that any request made to the court be made by motion, written motion before trial or during trial, and oral motion. And so even, I hear your argument, but I don't hear you saying any reason why this was error.
Well, Your Honor, it was error because number one, it chilled the litigants. They I hate to say afraid perhaps, but, and going back to Smith versus State,
I'm not sure anybody was chilled in this case. Just reading the transcript, it seems to me that there was very active participation in this case by the lawyers. And certainly there's no reason a motion couldn't have been made, but I'm just wondering, you know, give me some basis for the continuance.
Well, Your Honor, and this is getting into the orders for psychiatric evaluation, which we think were premature and beyond the scopes of Mississippi Rules of Criminal Procedure. The litigants, they were very active, Your Honor. It appears that they were bending over backwards to abide by the court's, for lack of, and I put it in my brief, so I'm going to say it here today, rocket docket announced that this trial is set for trial September 16th, and there's absolutely no reason that we see that this trial can't go forward. So everybody was bending over backwards to accommodate that trial schedule.
As they should, though, isn't it? I mean, that's what we want, is a speedy trial. We have so many cases come through here where it's delayed and delayed and delayed, and now we have one that's moving quickly through the system, which is supposedly the way it's supposed to work. And there's no basis in the record to say a continuance should have been granted.
Well, it was continuing in a speedy fashion at the expense of Carly's constitutional rights. The trial court ordered her to undergo competency and insanity at the time of offense evaluations before the 17.4 threshold of announcing the insanity defense had been met. And that is simply not what the rules contemplate. And in fact, the defense attorneys in this case filed a petition for interlocutory appeal to appeal that ruling. Her constitutional rights were we would submit, trampled on because they were ordered to turn over privileged information, medical records that they would not have otherwise have had to turn over to the state, but for the insanity defense, which at the time they were ordered to be turned over, had not been properly put before the court. Sure, the defense counsel at one point said that we intend to assert an insanity defense, but with all due respect to all of the attorneys that were involved in this case and even the trial court, none of us are psychiatric or forensic psychiatrists. And so for me as a defense attorney to announce at the beginning of a case before my client has even been evaluated by a forensic psychiatrist, and for me as a defense attorney to say we're going to assert the insanity defense, I believe is malpractice. Because I don't know what an evaluator is going to say once that evaluator reviews all the records and interviews Carly and makes a determination as to whether she has met the M'Naughton standard. So they were forced, they were given a Hobson's choice to either turn over those records and waive the privileges that go along with turning over those records, or waive the defense altogether, and they chose to preserve that defense. And until and unless they file the 17.4 notice of insanity defense, the court does not have the power, to order Carly to undergo psychiatric evaluations at the behest of the state. The court...
Does that apply? Okay, so the state made a motion, as I recall. Correct me if I'm wrong on this, because there's a lot going on in this record.
Yes, Your Honor.
And the court granted the state's motion and sent Ms. Gregg for evaluation, both as to competence to stand trial and the M'Naughton issue.
Correct, Your Honor.
But the psychiatrist, counselor, I don't remember which, to whom the court sent Ms. Gregg for that evaluation, reached an opinion as to competency to stand trial, but declined to issue an opinion on M'Naughton. Is that correct?
the initial state's expert, yes, that is correct.
All right, does the fact that that expert declined to address McNaughton or issue an opinion on that affect your argument that it was wrong to send her for that
Well, the
evaluation?
only reason she declined to render an opinion was because there were some issues with marijuana or some other.
Whatever the reasons were,
Right.
does that affect your argument that it was incorrect for the trial judge to
It
order that?
absolutely does not affect my argument. That was premature and that was incorrect and outside the court's power to order that exam at that point in time.
And you're saying that the harm that resulted from that is that it gave the defense's strategy up too soon and forced the defense to disclose documents it wouldn't have otherwise yet disclosed?
Among other things, yes, Your
But those documents would have been disclosed because the defense did pursue the insanity defense.
Yes, Your Honor. If the defense had ultimately chose to pursue the defense of insanity, those documents would have been produced. But if the rules had worked the way they're supposed to have, and the timing had worked the way the rules require, then the defense would have had Carly evaluated by their expert, who would have reviewed all those records and interviewed Carly and made a determination, yes, she qualifies for the McNaughton insanity defense, then you hand it all over. But if that, in contrast, if that evaluator and that expert had said, no, she does not qualify, then the state does not get the benefit of those privileged documents. The state does not get to have their expert evaluate her. So by jumping ahead and then ordering that the state gets to evaluate her ahead of time, it inverts the whole process. It gives the state access to documents that they may not have otherwise had access to. And with those privileged documents, of course, come waivers of communications that Carly had with her treating physicians and psychiatrists and counselors, among other things. And I think everyone would recognize, I think that we'd ask the court to take judicial notice that each evaluation of somebody would affect the next evaluation. And by virtue of the state having the first, I believe the state had the first opportunity to evaluate Carly because the defense's first expert was taking more time to evaluate her than was initially anticipated. And going back to that, they certainly weren't outside of their time limit. According to Rule 17.4, the defense has until the time for filing pretrial motions to assert the insanity defense. And in this case, the court's pretrial motions deadline was August 30th of 2024. The court started pressuring the reports back in June or July of that summer, well before the pretrial motions deadline of August 30th. So the court entered the order July 3rd that she submit to a state expert evaluation.
Okay, Mr. Murphy. Are there any other questions of Mr. Murphy at this time? Okay. All right, thank you, Mr. Murphy.
Thank you.
Okay. Ms. Hartman, the court will hear from you at this time. Mr. Murphy took an additional 9 minutes on his primary presentation, so if need be, the court will also extend additional time to you.
Thank you, Your Honor. May it please the court. Good morning. My name is Allison Hartman. I represent the state of Mississippi on behalf of Attorney General Lynn Fitch. This court should affirm Carly Gregg's first-degree murder and attempted first-degree murder convictions and her life imprisonment sentences because every aspect of her trial was fair and no errors were committed in the trial court. Gregg raised several issues related to both the guilt and penalty phases of her trial. Most of those claims are waived because she failed to contemporaneously object or otherwise raise those issues in the trial court. But even if we set the waiver bar aside, all of her claims lack merit and should be denied. I'd like to start with the penalty phase issues because it seemed like that was what the majority of opposing counsel's argument focused on, and then circle back to the guilt phase issues as time and interest allow. It's critical to establish at the outset that Gregg's sentence for first-degree murder is life without the possibility of parole, and her life imprisonment sentence for attempted first-degree murder.
Where do you see in the record that that's her sentence?
Your Honor, we have to look to the parole statute and the sentencing statute.
I understand that the parole statute prohibits parole for somebody who's been sentenced to life. And I understand we have cases that say essentially that means every sentence is life without the possibility of parole in effect. But there's an issue in this case regarding a jury instruction and regarding an illegal sentence. And because of that, I think it's important to see, separate from the application of the parole statute for a minute, what she was actually sentenced to.
So
And the sentencing statute in this case allows for 2 sentences: life in prison if that's set by the jury, and a term of years. All right, so the sentencing the sentencing order in this case sentences her to life imprisonment. So absent the application of a parole statute, which itself could be amended by the legislature any minute, I don't understand. I mean, I get why you say the effect of her sentence is life without the possibility of parole, and I think that's relevant to the Miller discussion. But to the illegal sentence and the jury instruction issue, I think it's relevant what that sentencing order says. So what the sentence, you will agree with me, the sentencing order says life imprisonment.
Yes, Your Honor, it
And
does.
you will agree with me that that is one of the legal sentences under the sentencing statute.
Yes, Your Honor. So the legal sentence under the statute, the amended statute, like you mentioned, is life imprisonment.
And if the legislature were to amend the parole statute in this next session, I don't have any reason to think they would, but if they did, and they were to remove the language that says you're no longer eligible for, the language that says you're not eligible for parole if you're convicted of first-degree murder, that's what relevates this effectively to a life sentence we've held, then all of a sudden she's no longer sentenced to life without possibility of parole. Is that correct?
I think, yes, Your Honor, because that's what the court did in Johnson versus State. That was this court. Johnson was originally convicted in 2000, which was pre-Miller, and he was sentenced to life without the possibility of parole, which was under the essentially mandatory life imprisonment without parole sentence, pre-Miller. And he successfully filed for PCR, and he received a resentencing hearing in the trial court, and the trial court conducted the Miller hearing, considered the Miller factors, and again sentenced him to life without the life imprisonment. And then this court interpreted that life imprisonment language, which is identical to what we have here, and it considered the parole statute and said that you have to read the sentencing statute and the parole statute to understand what the life imprisonment statute what the life imprisonment sentence actually is. And that when you consider those 2 statutes in tandem, essentially under the amended sentencing statute, life imprisonment is life without the possibility of parole. And I think that the court can just look to its own decision in Johnson versus State, which is really instructive on this issue because it's one of the only cases that actually interpret the amended sentencing statute that went into effect in July of 2024. And this court recognized there that you have to read the sentencing statute and the parole statute in tandem to give effect to what life imprisonment actually means. Because as Your Honor mentioned, life imprisonment is the maximum penalty under the sentencing statute. And you have to look to parole eligibility statute to determine what life imprisonment actually means.
In Parker v. State, we held that there should be a determination when that parole statute is in play. It's awkwardly worded, I think, but we said, let me find it, whether or not the defendant should be sentenced to a term of life imprisonment with eligibility for parole, notwithstanding the parole statute. Was there any attempt to instruct the jury on that or to raise Parker before the trial court to try to get a determination that the life sentence should be, notwithstanding the parole statute?
I'm sorry, are you asking whether the trial court should have...
I'm asking whether or not there was an attempt made to follow Parker v. State in the trial court. If you're going to sentence Ms. Gregg to life without the possibility of parole and claim that it's because the parole statute, forbids parole, in Parker we said there needs to be a determination of whether or not that sentence should be life with the possibility of parole, notwithstanding the parole statute. I'm asking you if that procedure that was laid out in Parker was followed in this case.
It was, Your Honor. At the sentencing jury instructions conference, the court and the parties were discussing the sentencing instructions, and there the court was looking at the state's proposed instructions and the defense's proposed instructions. And the court and the parties both acknowledged that under Miller there had to be a Miller compliant hearing, but also that under Mississippi's sentencing statute as amended, life imprisonment meant life without the possibility of parole. So all the parties recognized that under that first sentencing option in the instruction, life imprisonment was effectively a life without parole sentence.
That's effectively true, but that leads us back to the problem with the jury instruction, which is life without the possibility of parole is itself not a sentence, a legal sentence under the sentencing statute to apply to a juvenile for first-degree murder. It's not listed in statute, correct?
Yes, you're right. I mean, the plain language of the sentencing statute doesn't say life without the possibility of parole. It just says life imprisonment.
And so that jury instruction led the jury to believe, I mean, it just didn't follow the sentencing statute because it instructed the jury life without the possibility of parole or life sentence, which in the jury's mind, a life sentence meant, I guess, what? A life sentence with the possibility of parole, but that's not what the statute provides. In the statute, if you look at the two subsections together, in particular, it's pretty clear that a life sentence means, under the statute, life with the possibility of parole. So
I would disagree with that reading of the statute because I think you still do have to read the statute with the parole statute in tandem. I know that you're hesitant to concede that point, and I understand, but this court has held time and time again that the parole statute and the sentencing statute have to be read in tandem.
okay, and I might disagree with that because, again, what happens, we've sentenced a few people in this state to life without the possibility of parole because of the parole statute. What happens to the legislature? The legislature has in the past, has reformed the parole procedures and the parole, what if the legislature changes that statute and removes that language and all of a sudden makes people who are guilty or found guilty of first-degree murder eligible for parole? We have to go back and re-sentence everybody that was sentenced to life without the possibility of parole because we read the sentencing statute in tandem with the parole statute?
No, I think Johnson, this court's decision in Johnson versus State indicates that it's the statute that's in play at the time of sentencing. Because even though Johnson was sentenced in 2000, he was
The
re-sentenced.
sentencing statute.
Yes.
The parole statute is not a sentencing statute. The parole statute is a prohibition on parole.
Right. But in Johnson, this court also considered the parole statute that was in effect at the time that Johnson was re-sentenced.
Is that the court rewriting a parole statute as a sentencing statute when the legislature clearly intended to govern parole?
I don't think so, Your Honor. I think it's just interpreting what life imprisonment within the sentencing statute actually means. Because in order to determine what life imprisonment means, again, you have to consider parole eligibility. And to do that, you have to look at the parole statute. So the only way to interpret life imprisonment is to look at the parole statute to determine whether or not there is parole eligibility under that statute.
So, Counselor, how do you rectify the fact that one section of the statute says life and the other section says life without parole? Why bother delineating those two sentences in the statute if we're just going to pretend that there's no distinction between them?
I agree, Your Honor, that it's interesting that the capital murder provision and the first-degree murder provision are stated differently in the statute.
Do you think maybe that's because the legislature intended them to be handled differently in reality, in the world, in life, in court?
Possibly, Your Honor, but there is a distinct difference between capital murder and first-degree murder. We tend to look at capital murder as more severe, but first-degree murder requires deliberate design, intent, premeditation. Capital murder doesn't require that. It could
You can be convicted of capital murder without actually murdering anyone.
That's right. So
why do we make that distinction where somebody who does something that's not even as bad as murder or killing someone gets life without parole, and it's delineated in the statute, life without parole, but now you're standing here saying, oh, well, just ignore the fact that the section right above it just says life and doesn't add without parole. That's disingenuous, Counselor.
No, Your Honor, I'm not trying to say ignore that. I'm trying to point out the difference between the two provisions. And the capital murder portion of the sentencing statute also provides for the option of life with the possibility of parole, where the first-degree murder sentencing provision doesn't provide for the life with the possibility of parole. So I think there is an intentional difference there in creating an avenue for parole eligibility within the sentencing statute for capital murder.
But you're treating them the same. That's my point. Thank you.
Yes, but Your Honors, I think that if this court looks to Johnson versus State, it's very instructive on how this court should deal with this issue here today, because there, again, the court dealt with this exact sentencing statute and the parole statute. It read them in tandem, and this court said that under the sentencing statute, the language life imprisonment under subsection 2B, which is the subsection we're operating under, life imprisonment means without parole when you give the parole statute consideration. And that's what this court said, is that you have to consider the parole statute, and that once you consider the parole statute, life imprisonment in subsection 2B is without parole. And that's how, in this case, we know that Carly Gregg's life imprisonment sentence is without parole, and it's not with the possibility of parole. And kind of going hand in hand with that, Carly Gregg's jury had the discretion to impose a life imprisonment sentence, or if it couldn't reach that, then let the judge decide the penalty. And that's consistent with the United States Supreme Court's holding in Miller, which required an individualized sentencing hearing, after which the jury or the sentencer considers the Miller factors before imposing a life in prison sentence. And neither the Supreme Court nor this court have ever laid out step by step exactly how a Miller hearing is supposed to be conducted. If you look to Montgomery versus Louisiana, for example, or Chandler versus State in this court, or McGilberry, the Supreme Court and this court both say that the defendant has to have an opportunity to present evidence to support the Miller factors, and that the jury or the sentencer, because it could be the trial court in certain circumstances, consider the youth and its attendant characteristics using the Miller factors. And that's what happened here. Gregg had the opportunity to present evidence on the Miller factors, and her defense trial strategy was to focus on allowing the judge to sentence her instead of the jury, because the sentencing authority of the judge was only 20 to 40 years. So I think her trial strategy was clear, to hope that the judge would sentence her and not the jury, so that she could get a lesser sentence. But the jury instruction, SS1, which is at the clerk's papers 1093 to 1094, it lays out the Miller standard clearly, and it says it instructs the jury what the Miller factors are, and it instructs the jury to consider those factors in determining whether or not it should sentence Gregg to life imprisonment. And that, in effect, was the Miller hearing. Just because Gregg now says that she wished she presented more evidence doesn't mean she didn't receive everything that she was entitled to under Miller, which was a separate individualized sentencing hearing, and the jury considered the Miller factors and exercised its discretion to impose life imprisonment instead of letting the judge decide her punishment. And I think, circling back a little bit, I think on the jury instruction issue, it's also crucial to recognize that Gregg not only didn't object to the state's proposed jury instruction, which is SS1, but she actually withdrew her own proposed instructions and acquiesced to the state's instructions. So I think that goes beyond waiver, and the fact that Gregg agreed to those sentencing instructions, and now she can't come back on appeal and claim that the trial court erred in giving those instructions because she agreed to them. As I mentioned, Gregg received everything she was entitled to under Miller. That individualized sentencing hearing, the jury considered the Miller factors, and the state presented sufficient evidence on each of the Miller factors to support the jury's verdict. It submitted evidence on her chronological age and how her maturity level, education level, ability to maintain relationships overcame her young age, which was 14. Her family and home environment. She had a tough upbringing in the beginning, but once she moved out from her biological dad's house, for all intents and purposes, she had a great home life. Her parents supported her hobbies. They took her to guitar lessons, karate. They supported her academic success, and most notably, when she expressed any issue with her mental health, they immediately took her to get psychiatric and therapeutic help. And then the other Miller factors, the circumstances of the homicide offense. Obviously, the jury here heard significant evidence about the horrific nature of the murder. It heard and saw photos where Gregg shot her mom 3 times point-blank range in the face. So obviously, that the circumstances of a homicide offense weighed in favor of the life imprisonment sentence. So this court should affirm her sentences because she had a Miller-compliant hearing, the jury instructions adequately tracked the statute, and the state submitted sufficient evidence to support the imposition of the life in prison sentence. And I also want to briefly touch on Gregg's claim regarding the prosecutorial misconduct.
Let me ask you to back up. Your comment about the jury instruction adequately tracked the statute, and I hate to keep coming back to this, but the statute, when you say the statute, the sentencing statute does not have an option for life without the possibility of parole.
Yes.
It does not have that possibility.
That's right.
So when we're in a situation because of a case from this court, the Johnson case, the cases where we've basically held that effectively every life sentence is without the possibility of parole, so we might as well go ahead and sentence them to that. But we're in a situation where trying to work with that precedent from this court can even make the argument plausible that a jury instruction that flat does not track the language of the sentencing statute itself tracks the language or tracks the law. Doesn't that seem like a problem for you, where we can't actually track the sentencing statute that the legislature chose, which, by the way, these amendments took place after Johnson. They took place after Miller.
Yes, Your Honor.
That doesn't seem like a problem to you, that we have to actually not track the statute to track the statute?
Well, I think the sentencing instruction did track the statute, and that it said life imprisonment was the option, not life without the possibility of parole. So it didn't actually, the sentencing instructions didn't actually say life without the possibility of parole. It just said life imprisonment, and that's what the jury sentenced Greg to. Then we know that's without parole because, again, going back to the parole statute, which says that first-degree murder is not a parole-eligible conviction. So technically, Your Honor, the instruction did track the statute, especially when you consider the parole portion of the statute. If Your Honors don't have any more questions about the penalty phase of Greg's trial, I'll move on to the couple issues that opposing counsel raised regarding the guilt phase. First, in regard to Greg's argument that the trial court prospectively denied all motions for continuance, I think that's a stretch to say that the trial court expressly denied any motion for continuance. This was during a status conference where the parties were discussing deadlines and how the case was scheduled in terms of proceeding forward, and the court just expressed his general dislike for continuing cases. But it's critical in this case that Greg never moved for a continuance. She never sought more time. She never indicated that she needed more time to do anything. So there was nothing really right for this court to consider because there was no denial of any motion. So we would just argue that she waived that claim and that there's no decision for this court even to review in regards to the, quote, prospective denial of motions for continuance. Turning to the M'Naughton issue, really Greg argues form over substance here, because the truth of the matter is that from the beginning of the pretrial hearings, the scheduling conferences, status conferences, she repeatedly indicated that she intended to pursue the insanity defense. We cited in our brief a thorough account of all of the instances where she expressed her intent to pursue an insanity defense to the trial court, and we would also refute her contention that the state had the first chance to have her evaluated. It was the court who appointed Dr. Gugliano originally to evaluate Greg for both competence to stand trial and M'Naughton insanity. And as Your Honor recognized earlier, Dr. Gugliano did not feel comfortable proceeding in doing a M'Naughton evaluation based on the fact that Greg was on some drugs and that there was some medication history in regards to what she was prescribed. So after that, Greg hired her own expert, which was Dr. Webb, to conduct her evaluation. She ended up not using Dr. Webb, hired Dr. Clark, who had the first opportunity to evaluate her, and he just wasn't finished with his evaluation when the state's expert, Dr. Pickett, began his evaluation. And importantly for this point, again, is the fact that Greg didn't object to any of this occurring. There was never a point in time where the trial court said he was going to appoint experts to conduct M'Naughton evaluations, that Greg said, no, we object to that, we don't want her evaluated, we're not going to plead insanity. Her only request at any time was that her expert evaluate her before the state's expert. But even when the state filed its formal written motion seeking to have her evaluated under M'Naughton, Greg did not object, and in fact, in the trial court, it asked, do you have any objection to the state's motion? And they said, no, Your Honor. So I think that any argument she makes that she should not have been evaluated under Monotton before filing her 17.4B notice is really mooted by the fact that she herself acquiesced to being Monotton evaluated even before filing that 17.4B notice. Your Honors, if you don't have any further questions on any of the issues, then the state would rest on its brief and urge this court to affirm Gregg's convictions and sentences.
Any questions for Ms. Hartman? Thank you, Counsel.
Thank you, Your Honors.
All right, Mr. Murphy.
How much time do I have? May it please the court. I'd like to address a couple quick points, if I may, before I move on to some more substantive argument. I believe it was Justice Sullivan who asked counsel whether the legislature could have, whether it's possible that the legislature intended for life in subsection 2B as it applies to juvenile first-degree murder, whether the legislature could have intended that that be life with parole irrespective of the parole statute, and counsel responded, possibly. I think that is very telling, in that I think at the very least, while we would assert that it very certainly does indicate that the legislature intended that, but we would assert that the state has now conceded at the very least that there is some ambiguity as to whether the state or the legislature intended that or not. And as I think the court is well aware, the brief that we cited, we included all of the canons of construction when the court is interpreting statutory construction, and one of those rules is the rules of leniency. And the leniency rule states that if there is a distinction to be made, if there is an ambiguous statute, and there are two interpretations, the interpretation that is most lenient to the defendant is the one that the court must adopt. And in this case, that adoption would be that the statute that was amended and in effect at the time of the sentencing is that Carly's sentence is life with the possibility of parole. I'd like to make that quick point. And also, Your Honor, I'd like to address, Your Honors, I'd like to address the state's reliance on Johnson v. State. 2 points I'd really like to make about that and why the state's reliance on that is misplaced. Number one, I believe it was Justice Coleman who pointed out that was decided well prior to the amendments to the statutes and in response possibly to Miller. But that case involved a very thorough Miller sentencing hearing. And that is distinguished from this case because there was no Miller sentencing hearing. There was, and again, I've used that term loosely, there was a sentencing hearing, but that was very, in effect, it was a sentencing argument. So in the case at bar, unlike in Johnson, we had no sentencing hearing, and I believe Miller not only stands for the proposition that there are certain factors that a jury or a trier of fact or whoever is deciding the sentence must consider. You can't just throw all these factors that the jury must consider at the wall and assume that they're going to consider them. So there's a substantive aspect to Miller, but there's also a procedural aspect to Miller. In other words, is the defendant given adequate process, adequate notice, and an adequate opportunity to address those Miller factors? And in this case, there was absolutely no notice that we're moving into the sentencing phase. I'm not even sure, prior to the court turning to the state and saying, present your first sentencing witness, I'm not sure whether the litigants were even aware that that was going to happen. I certainly don't see anything in the record where the sentencing order or anything like that outlined that that was going to happen. But certainly the defense was not afforded any due process to address those Miller factors. And so we would move or posit that Johnson is really inapposite to Carly's case. Another issue that we would point out, and I'm just going to read from our brief, the state's reliance on Johnson v. State is misguided. According to the state, and I'm quoting from the state's brief, this court held in Johnson that the trial court's application of section 4773 to sentence Johnson, who was 17, when he committed first-degree murder to life imprisonment without the possibility of parole after a Miller hearing was not an abuse of discretion. Thus, in harmony with Miller, Section 97.3.21.2b allowed Carly Gregg's jury to sentence her to life without parole consistent with Section 47.7.3d, which is a parole statute, but only after it considered the Miller factors. However, the trial in Johnson occurred in 2000, as I think Justice Coleman and Justice Sullivan and perhaps a couple of other justices pointed that out. The trial in Johnson occurred in 2000, nearly 2.5 decades prior to the amendment to 97.3.21 from Senate Bill 2022 of our 2022 of our legislature's regular session in 2024. And now, if I may, we did not address this in the initial argument, but I would like to address one of the errors that we have alleged that the defense did object to, and that was the introduction of the crime and punishment summation by Rebecca Kirk, who was one of Carly's counselors. During the state's rebuttal case, the state elicited testimony from Rebecca Kirk, who was, again, one of Carly's counselors, to summarize. Well, first she was asked what books Carly had read or was going to read, and there were several books that were mentioned. One of them was The Bell Jar, another was The Castle, and then there was Crime and Punishment. Curiously, the state did not ask Rebecca Kirk to summarize The Castle or The Bell Jar. The only one that they asked Rebecca Kirk to summarize was Crime and Punishment. And this was over objection of defense counsel. And this was over objection of defense counsel after pointing out to the trial court that there's no proof that Carly even read the book at the time of the trial. Now, we would dispute whether or not that was ever established. I think in cross-examination, I think defense counsel got Ms. Kirk to admit that maybe she said she was going to read it, but she hadn't definitively read it or not. But whether she had read the book or not is really irrelevant. The plot of that book was a sensational plot that, as summarized by Rebecca Kirk, it was about a hatchet-wielding murderer who tried to assert the defense of insanity and then got away with it and was unremorseful and unrepentant. That was the summation of Rebecca Kirk. Now, not only would we assert that that was an incorrect recitation of the actual book, but at the very least, it was the important points that Rebecca Kirk remembered about the book. It was not the important points that perhaps Carly Gregg would have remembered about the book. But be that as it may, the only reason that the prosecution would want Rebecca Kirk to summarize that book is because the prosecution wanted that jury to hear those sordid details about that book and associate those details with Carly Gregg. They wanted the jury to think, well, if she read that book, she must have been she must have had those thoughts, and she must have hatched the plot to plead insanity after she read that book. That is exactly what the prosecution wanted the jury to believe, and that was over the objection of the defense. Now, I believe it was Justice King, and I believe Justice Coleman joined Justice King in an objection in Jordan v. State, which was an en banc split decision by this court rendered in 2016, which was reviewing a affirmation of an appellate court. The Court of Appeals affirmed a finding of guilt after the prosecution was allowed to introduce rap lyrics. The Court of Appeals affirmed the conviction, and then the Supreme Court was split evenly 4-4. Again, I think Justice King filed an objection. Justice Coleman, I believe, joined in that objection. And there were several things that Justice King cited in his objection. And I believe that court cited with approval a New Jersey case, State versus Skinner. In that holding, in State versus Skinner, the New Jersey Supreme Court held that lyrics were highly prejudicial and carried little or no probative value because they were expressive, fictional writings and not tied by a strong nexus to the charged shooting in that case. Just as in this case, there is no nexus between what the writer of Crime and Punishment wrote and what was alleged that Carly did. There was no nexus. It was not even established that she had read the book. And I want to read a quote because I think it's extremely instructive from State versus Skinner. The difficulty in identifying probative value in fictional or other forms of artistic self-expressive endeavors is that one cannot presume that simply because an author has chosen to write about certain topics, he or she has acted in accordance with those views. One would not presume that Bob Marley, who wrote the well-known song, I Shot the Sheriff, actually shot a sheriff, or that Edgar Allan Poe buried a man beneath his floorboards as depicted in his short story, The Telltale Heart, simply because of their respective artistic endeavors on those subjects. The defendants, in that case, lyrics, should receive no different treatment. In sum, we reject the proposition that probative evidence about a charged offense can be found in an individual's artistic endeavors, absent a strong nexus between the specific details of the artistic composition and the circumstances of the offense for which the evidence is being adduced. And I would take that a step further. That case and these cases that we cited in our brief, including Jordan v. State, Brooks v. State, United States v. Curtin, involved artistic works that the defendant was alleged to have written or participated in some form or fashion. In Carly's case, the artistic work at issue is a book that she had absolutely nothing to do with writing. She did not write that book. She had absolutely no contribution to the themes that were found in that book. So we would submit that the propositions cited by Justice King and Jordan v. State, by the Jersey Court and State v. Skinner, by the Ninth Circuit and United States v. Curtin are even more applicable in the case at bar than they were in those cases. And we would argue that the court erred in allowing the state to introduce that testimony.
Thank you, Mr. Murphy.
And if there are no other questions by the justices, thank you, Your Honors.
Ms. Hartman, Mr. Murphy did not mention the crime and punishment argument during his initial presentation. Out of a sense of fairness, if you'd like an opportunity to respond to that, the court will give you a couple of minutes.
Thank you, Your Honor. May it please the court. So the majority of Greg's argument for crime and punishment is essentially relevance, and that any relevance it did have was more prejudicial than probative. But that's not the standard. The standard is under 403 whether the probative value is substantially outweighed by the risk of unfair prejudice.
Well, Counselor, first you do have to answer the relevancy question.
Yes, Your Honor.
So there's no evidence that Ms. Gregg read that book, correct?
I would disagree with that, Your Honor.
She said she told the counselor she wanted to read the book.
And then she told her that she completed the reading.
Oh, she did say that?
Yes.
I'm sorry. Where is that in the record?
Let me see if I have that written exactly down here. I don't have that citation on my outline, but it is in our brief. I argue that point in the brief. So I know that I cited it there. And essentially, Rebecca Kirk and Gregg discussed those three books before spring break, and then they went on spring break, and then the appointment right after spring break, Gregg told Rebecca Kirk that she had completed the reading. So I think from that, it's a fair inference that she read the book.
So, and I'm sure you're correct. I'm sure that's in there. So assuming that it is, I still ask the question, what disputed fact in this case does that her reading of the report that she read that book make more or less likely to be true?
I think because the defense put on an insanity defense and they called Dr. Clark to the stand to testify that Gregg was criminally insane under M'Naughton. He testified that he relied on Rebecca Kirk's treatment notes, and then the state called Rebecca Kirk to rebut Gregg's insanity defense and rebut Clark's testimony about her not insanity. So it's our contention that that's relevant. Her state of mind, the materials she was ingesting, the discussions she was having with her therapist, even about these difficult and complicated classic books, bore on Rebecca Kirk's testimony about her treatment of Carly Gregg, even just 24 hours before Gregg went and murdered her mom. So I think that Rebecca Kirk's treatment notes, including that reference, are relevant to the state's rebuttal of her insanity defense. And Your Honors, even if this court is inclined to hold that Rebecca Kirk should not have been permitted to testify about the summary of crime and punishment, I think this is a classic example of harmless error because Gregg was not convicted because Rebecca Kirk summarized crime and punishment on the stand. She was convicted because the state presented extensive and overwhelming evidence that she was sane at the time when she murdered her mom and that she committed the murder with deliberate design. Just a few examples. She appreciated where the security cameras were in the kitchen. She hid the gun behind her back when she was in view of the security cameras so that the camera wouldn't see it. She covered her mom's face with a towel after she shot her point blank in the face 3 times. She called multiple friends on the phone and said things like, "I messed up, don't call the police," things that would indicate that she knew what she had done was wrong. She even took her mom's cell phone off the counter right after she murdered her, put in the correct passcode, and then went in the phone, found Heath's contact information, and texted him and asked when he would be home, acting like Ashley. This and abundance of other examples prove that Gregg murdered her mom with deliberate design, but more importantly, that she understood the difference between right and wrong when she murdered her mom, so she was sane under Monotone. So irrespective of the crime and punishment summary, Gregg would have been convicted, and this court should affirm her convictions and sentences. Thank you, Your Honors.
Thank you, counsel. The court appreciates your arguments and will take this matter under advisement and render decision in due course. We stand adjourned.
We'll begin with docket number 168. The state filed a motion in limine to exclude motion of punishment. The defendant filed no response. Granted. Give me an order to that effect.
Yes, sir, Your Honor. One question regarding that punishment as well. The attempted murder statute requires bifurcation both for guilt and sentencing. And of course, we would ask that any comments about sentencing be reserved for that, for the murder and the attempted murder.
For the sentencing things, yes.
Yes, sir.
All right, docket number 169, motion in limine to exclude golden rule and jury nullification arguments. No response was filed. It's granted. State's to give me an order. All right, motion document number 170, motion in limine regarding facts not in evidence. No response was filed. Granted. Give me an order. Document number 171, motion in limine regarding speaking objections. No response was filed. Motion is granted. Document number 166, motion to suppress urine test. Heard from the state. I read the state's motion. Excuse me, I read the defense's motion. I read the state's response. State's burden of proof. Do you have any witnesses you wish to call?
I'm sorry, Your Honor.
It is the state's burden of proof. Does the state have any witnesses it wishes to call?
Sure, Your Honor. The state calls Corey Gerber.
All right.
Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. Do you understand that you're not under oath or answer to sworn answers after all required?
I do.
You may proceed.
If you would introduce yourself for the record.
My name is Corey Gerber.
And Mr. Gerber, what is your role currently?
I currently serve as the Rankin County Youth Court Prosecutor.
As a youth court prosecutor, do you have experience in information regarding what happens when an inmate is intaked at the juvenile detention facility?
I do.
And is there a policy and procedure put in place regarding drug screening of all offenders once they're taken into custody?
It is the practice of the Juvenile Detention Center to drug test everybody that is brought in. That is my understanding.
And to be clear, could you explain for me kind of the breakdown out at the Juvenile Detention Center? There is the youth part, the court part, of which you're a prosecutor, and then there is the detention part, is that correct?
They're two separate entities. The Juvenile Detention Center is run by the sheriff. The Rankin County Youth Court is the court, and they are separated by locked doors. We are two separate entities, yes.
Hold on just a second. Let me check. It's on my
Testing.
Mr. Gerber, you said that each inmate is drug screened at admission. Could you tell the court what's the purpose of those drug screens?
My understanding is that every child detainee that is brought to the Juvenile Detention Center is drug tested for the purposes of safety. There are multiple things that are done when a child is brought in. One, they are to meet with a mental health crisis assessor. The other is they are drug tested. And my understanding is that they are drug tested just to make sure that whatever substances are in their body for purposes of medical care.
And are you familiar with the drug screening that's done in conjunction with that?
I am.
Could you tell the court about that?
So those are observed screens. Those screens are taken. Once the screen is done, they are presented to the lab. Then the lab would run those tests. The lab is on site. That is a very expensive piece of machinery. I am not an expert in how that machine is run. I can tell you that that machine is calibrated once a week. Every time that the machine is started before any tests are run, there are controls that have to pass. You have 3 attempts to pass those controls. If the controls do not pass at that time, the machine has to be recalibrated until the controls do pass. Otherwise, we did not run the test.
And Mr. Gerber, do you have any personal knowledge about whether or not that machine was running appropriately on March the 20th of 2024?
I do not have any personal knowledge other than if it wasn't running appropriately, it would not have been running.
So they would not have performed a test if it was not working appropriately?
They would not have ran the test if it was not working appropriately, no.
You talked about that there's some checks and balances in place and calibration to make sure that the machine is running correctly. How reliable are the results from these particular drug screens?
They're very reliable. If they weren't reliable, we wouldn't use them. We wouldn't waste anybody's time or money doing the tests. I will say they are not confirmed tests. So typically what you have is whenever a urine test is had and you get a result, if that result is a positive test, what would typically happen in a case like that is that urine would be sent off for confirmation. We do not do that. We use that test primarily for assessment, not for any evidentiary value. We are not presenting that information to the court without some other types of discussion.
And so the screening's done for safety. The screening has some checks and balances in place, and you said that the results are very reliable. So if someone had presumed tested positive during one of those screens, like the defendant did in this case, that would be very reliable?
It would be reliable. If there was any question, typically what we would do is send that person for a separate test. Depending on what you're testing for is going to be the question. There are some things that we test for that are not as reliable as others. An example would be methamphetamines. Those are the ones that we typically have the question on. We do send those. We don't send that urine for confirmation. Instead, what we do is send the person out to give another sample and have that sent for confirmation.
Court's indulgence. Mr. Herbert, with regards to the test performed by Carly Gregg, has anyone provided you anything to show that that particular test was not reliable?
I don't recall seeing that test, nor has anyone mentioned that it wouldn't be reliable.
No further question, Your Honor.
Cross-examination.
Thank you, Your Honor. Now, Corey, okay, why was
Carly at the youth detention center to begin with?
Under federal statute, a child cannot be detained in an adult facility without an interest of justice hearing being had within 6 hours of that child being detained. So as a courtesy to the judge, Carly would have been at the juvenile detention center until a hearing could be scheduled for purposes of that interest of justice. She was there long enough for that hearing to be scheduled. She was transported from the juvenile detention center to the jail here or to the court. I'm not sure where she was sent after that, but that hearing was scheduled.
Okay, so, because she, according to the statute, she's considered an adult, correct?
Yes.
Okay. And so, my understanding, why is it that everybody is tested in the, I guess, in the youth detention center? Isn't there some federal grant that y'all are under that requires that?
I'm not certain whether there's a federal grant that requires everybody to be tested or not. Again, my understanding is they are tested out there for purposes of safety issues, safety reasons.
Okay, so she was only going to be held there for a few hours until she could be brought over here to Rankin County.
As soon as the hearing could be scheduled, correct.
Okay, and so there wasn't a warrant or anything like that to have her do this test, correct?
Not that I'm aware of.
And there was no probable cause where somebody was saying that we want this test done, correct?
I'm not certain. The only thing I can say is that she was tested for the same reasons that anybody else that would be brought to that detention center was tested for.
Okay. But she was an adult and everyone else would have been children, correct? Or youths? Okay, correct?
She would be classified as an adult, but she's still a child.
Yes, I agree with you. She's still a child, but she would have been classified as an adult.
Yes.
Okay. And so, now when you were talking about the test itself, and you said that it's calibrated once a week. Okay. Is there like a logbook that you have that says that it's calibrated?
I don't calibrate it. I just know that the protocol, the practice is that it is calibrated once a week, and that's going to be the first start, typically on Monday.
So you don't know if these things are even kept. Is that correct?
Oh, I don't know. Okay. I'm not the person running the machine.
Okay. And the night that this happened, who ran the machine?
I have no idea.
Okay. And if I showed you the test card, would you be able to tell us who ran the machine?
Yes.
Okay. May I approach the witness, Your Honor?
Yes, you're showing the counsel opposite. Anything we're going to show the witness, let's mark that application.
No objection, Your Honor.
Can you mark that P1 for identification? Yeah, that's the test card that we have. In fact, that's the only document that we have concerning this test.
This is the only document. There's no there's no back sheet to this.
That is the only document that we've been presented.
Then no, I can't tell you you ran the test.
Okay. From looking at that document, can you even say that it's calibrated or it's been checked or anything?
I can't. Not from looking at this document, no.
Okay. Now, do you, I guess, once these samples, I guess these samples are given, and you said they're taken to the lab, and the machine's in the lab, is that correct?
That's correct.
And then they're run at that, the samples run at that point?
It is run once the machine is started. So a better answer for your question is that if the sample is taken at night and it's placed in the lab would be started by the person that runs the machine when they would get there the next morning, and then it would be ran in. So I don't know what time this was taken. I can tell you the date that it was taken based on this. It was collected on the 20th, according to this sheet, and it would have been ran the same day at 9:21.
Okay. And when these samples are, I guess, run, what happens, I guess, is there going to be extra fluid, or is it marked and then it's put in the, I guess you'll have a refrigerator or something?
So yes, that we do have a refrigerator, but no, the extra fluid is disposed of. We do not keep the urine, not to my knowledge.
Okay, so you run this test. So let's get back to this where you say you use the test for, because the test is for the youth court, basically. Is that correct?
Well, it depends on the case. I mean, yes. I mean, if this child were to be a child under the jurisdiction of the youth court, this test could be used for multiple things. One, to give the detention staff an idea of what is in that child's system for purposes of maintaining the child at the juvenile detention center. The second could be for purposes of disposition. The youth court is a court of rehabilitation, and we want to address the whole child. So if I see this particular test, I can tell you that it's positive for cannabinoids in an amount of 237.7 nanograms per milliliter with a cutoff of being 20. That would indicate that this child has consumed some type of cannabinoids. We would want to know that moving forward for purposes of A&D assessments and possibly enrolling them in some type of program to address cannabinoid use. If there is a question as to whether or not this is accurate, what would happen at that point is we would send that child for something else. But these tests are reliable, they're just not confirmed. So there is no, I would not use this as an evidentiary test.
Right, and that's what I'm getting at, is an evidentiary test to say that is actually what it is. That's not what you use them for, and that's not what they're designed to be used for, correct?
That's not what I use it for. Again, this is just an assessment tool used by the court for purposes of disposition. In the event that there's no contest between the child or the person, the donor, sometimes adults get these tests. If there's no contest about what is found in these tests, at that point they can be submitted to the court. But I do not submit these to the court for evidentiary value at adjudication.
And so where we're at right now is, you said they're calibrated. There's no calibration documents or anything that I provided you or that you have in front of you, correct?
I don't have it, no. If you haven't provided me with it.
And I think the only thing I gave you is a test card that was given to us.
That's correct.
Okay. And so that doesn't tell who did the test. It doesn't say if the other safeguards have been done on the test. It doesn't. Is the person even qualified who ran the test? We don't even know that, do we?
I will tell you that there are only certain people that are allowed to touch that very expensive machine. They are all qualified to run it. But I can't tell you who did that particular day. As to your other question, it was collected by someone in the Rankin County Sheriff's Department. So that would be a detention staff. But I do not know who that would have been. That information can be gathered, but I don't have it.
No further questions, Chairman.
Can I read the exhibit with my court reporter?
Yes. I'm trying to steal your exhibits.
Read away.
Raise it, Your Honor. Mr. Gerber, as I understood it on cross-examination, you said these tests are for, again, safety and medical purposes for the detention staff as well as the donor?
As well as disposition. In the adult world, that would be sentencing. We want to make sure that we have all the information available to us to make sure that the rehabilitation process happens. So they have multiple uses, yes.
When the detention center finds someone is tested positive for a substance like Ms. Gregg did in this case, why is that important for them to know from a safety standpoint?
Well, for example, if it had been fentanyl, we would have taken the child directly to the hospital. The other is we want to make sure that there's no interaction with anything else that's going on. I don't work in the detention center. I don't want to speak for them, but I mean, I think it's fairly obvious that we want to know if the child is under the influence of any type of drug while they're in the detention center.
And if the child admits that they've used drugs, would that tend to corroborate the test results as well?
Yes.
Do you have any information that Ms. Gregg did not corroborate this test as you sit here today?
No, I don't have any information.
No further questions, Your Honor.
Stand down. The state may call its next witness.
No further witness, just the argument, Your Honor.
Defense have any witnesses that wishes to call on this issue?
No, Your Honor.
All right, argument by the state.
From here, the voting, Your Honor. The state outlined in our response and then filed an amended response. I want to bring that to the court's attention. Initially, we believed that the Juvenile Detention Center was under a particular grant through the OJJDP, which is the Office of Juvenile Justice and Delinquency Prevention. That federal grant does require drug testing. Upon communications with the Board of Supervisors, it's actually a different grant than we initially cited in our response. So I did file an amended response attaching the appropriate grant that does in fact require drug screens of all offenders at entry. Or that does require, drug screens, as well as the Rankin County Sheriff Department's Juvenile Detention Center Policies and Procedures 2.2F. Those were provided to me by the Sheriff's Department, which again outlined that each offender is screened there at the detention center immediately. It also outlines the policies and procedures that are to take place upon entry. These screens, as you heard from Mr. Gerber, are very reliable. The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least. We believe that this information is certainly pertinent since she has asserted her right to claim an insanity defense. As this court's well aware, in cases such as Crawford v. State, once the defendant puts their sanity at issue, the door is thrown wide open for the admission of evidence of every act of the accused's life relevant to the issue of insanity or sanity and is admissible in evidence. That's Crawford v. State, 867 Southern 2nd, 196. Additionally, Mississippi Rules of Evidence 703 states that an expert can rely on facts and data that are not necessarily admissible in evidence. And so our doctor, Dr. Pickett, has relied upon Carly's admissions of using marijuana as well as this presumptive test to show that is and does call into question her mental state. As this court is also aware, voluntary intoxication is not a defense to murder. It does not entitle you to an insanity defense. And so we believe that 703 as well as Crawford and the admissions by the defendant make this test even more reliable. This isn't just a piece of paper that shows that she had marijuana in her system. We have the defendant herself saying that she'd smoked marijuana at or around the time of the crime, as well as additional witnesses that we intend to introduce. As outlined in our arguments, we also believe that this urine screen is akin to the DNA buccal swab found in Maryland v. King. There was a 3-part test. We believe that it's similar in that the Rankin County Detention Center's booking policies require that all offenders be screened, that urine sample is the least and minimally invasive drug screen that's available to them at the time. And as such, we believe that the drug screen itself should be admissible under Maryland v. King. Also as cited in our arguments, and what Mr. Gerber talked about today was that these tests are done for the safety of both the offender as well as the facility. And we believe that that record is actually a part of Carly Gregg's medical records. And because of that, and because of her claim of insanity, she has waived all medical privilege with regards to anything that might have to do with her mental state at the time of the crime. Specifically, we cite to Rule 503F of the Mississippi Rules of Evidence, as well as the cases outlined in our response. We ask that the state be allowed, that our evaluating psychiatrists be allowed to review and talk about the results from this urine screen as they do affect the defendant's mental state at the time of the crime. And then additionally, We would argue that if a search warrant was required, Holloman v. State would apply. In this case, it was a drunk driver who killed someone driving in a car. Law enforcement was on the scene. They observed the presence of beer cans, empty syringes, and bottle containing unidentified liquids. At the time, the person's blood was drawn, and also a urine sample was taken. There was the presence of methamphetamines and cocaine. This sample was taken without a warrant, similar to what we have here, and the court found that a warrantless search is permissible in certain exigent circumstances if it can be shown that grounds existed to conduct the search that, had time permitted, would reasonably have satisfied a disinterested magistrate that a warrant should be properly issued. And similar to Holloman in this case, the substances that were in Ms. Gregg's system at the time can dissipate over a period of time. And this screen was done on the 20th. She was brought over hours later, and we would argue, Your Honor, that if a warrant was if we had received a warrant, had to serve it on her and get an additional sample, that would be even more far removed than this sample was on the 20th rather than the 19th at the time of the crime. We would, of course, also state that, as pointed out, it's going to come into evidence that Ms. Gregg was using marijuana. And we believe that if it doesn't fall under the warrantless search and for the safety and within her medical records and the alternative, the state would argue that this would fall in the inevitable discovery doctrine. And admittedly, under that doctrine, you have to show that law enforcement, there was some misconduct, and that but for the misconduct, these items would have come forward. There's been no such misconduct in this case. However, there is a test that outlines when things would come into play if it was inevitably discovered, and we believe that's the same thing with a shearing screen. Based on admissions by the defendant as well as other evidence, law enforcement had at the time in their possession illegal substances, the presence of the vape pens that they had seized from the house, and knew of the fact that there may be a potential for drugs to be in her system. We would certainly ask, Your Honor, to consider all of those exceptions and rule that the urine screen would be admissible for its purpose of showing that marijuana was in fact in her system and not for a quantitative state.
Response.
Thank you, Your Honor. First of all, Your Honor, I'm just going to briefly touch base. The state brought up the fact of basically the indigent circumstance where you can draw blood. The Supreme Court of the United States changed that in McNeely, Missouri versus McNeely in 2013. You now have to have a warrant. So when the state's saying that you do not have to have a warrant in that type, like in the Holloway situation, that was a different time. That was okay at that time. That would have been under the Shoemaker ruling, which said that there were exigent circumstances and that you could get away with not having a warrant. That has now changed. The one thing I want to say is that with this charge, Carly was charged as an adult, and she was taken to the youth detention center, and it puts her in a different status than most people that are going to the youth detention center. Most of the people that are going to the youth detention center are being handled as youth. In fact, I would say all of them except a very small, minute amount. In Carly's situation, she's entitled to due process, which is there has to be a warrant, there has to be probable cause, there has to be some of the protections built in. They bring up the Maryland v. King case, and they say, well, in Maryland v. King, there was actually a state statute that mandated certain testing. And the Supreme Court was looking to see if that was viable, if that was a viable law. And they came back and they said, yes, that there was it validated the law. It said that there was a judicial reason for them to have the law, to have the testing. So therefore, what they did in Maryland versus King was okay. That's not the type of situation that we have here. There is no Mississippi law, there is no federal law that says that this shall be done. This is just the policy and procedure of the Rankin County Detention Center. And so what's happened is she's entitled to due process, and that didn't happen in this situation. There is no probable cause, there is no warrant. That was testified from the stand. And the next thing that I want to bring up and put to the attention of the court, in order for a test to be valid, you have to have the person, and this is under Mississippi law, and this is any of these chemical tests, you have to know who the person is performing the test. You have to know the testing procedures. It has to be laid out somehow, and it has to be presented to the court and say, hey, this is done. And then the last thing is there has to be something to show that it's reliable. The way they show that it's reliable is having calibration records. You have the information of who did the test, how it was done, when it was done, and it was done according to the way the test was supposed to be carried out. We don't have any of that. The only thing that has been presented to us is a one-page paper, and on the bottom of the paper, it's document 1 of 1. It's not 1 of 10 or something like. There's a whole bunch of other documents that go with it. You have a test card. The other thing that comes into play is the state is wanting, they say, well, first of all, the test is not designed to be a standalone test. It is not to say what you're seeing in that test is what's in her system. It's only an identification test. They use it for that purpose. They do not use it for evidentiary purposes. What the state's wanting to do is take that test and then turn it into evidentiary purposes. They say, well, we just want to have it as like an identification kind of thing. Well, no, they're wanting to, in their reports, they're going in and trying to say whether or not she's under the influence at the time based upon that test, which is an invalid test. It does not show, it doesn't meet any of the requirements of being a valid test by how it was done, who did it, was it calibrated, did they follow the protocols, none of that stuff. None of it has been provided to us. And also, there's been no consent. There's been no testimony that there's no consent. There's no warrant. The test wasn't done right. It's being used for a different purpose than what the Youth Detention Center uses it for. For all those reasons, Your Honor, we ask that the test be excluded at this time.
Mr. Mackey, you reply.
Yes, sir. I believe that Missouri versus McNeely deals with warrants for blood draws, and in this case, we're talking about a urine screen. Also, Mr. Camp mentioned the laws in Mississippi and the statutes about calibration, and I believe what he's referenced it to is the implied consent law, which talks about intoxilizers, not the drug urine screens. Again, we believe that this does fall within the exceptions as cited in our amended response and also argued today. And more importantly, we believe that it falls within Ms. Gregg's medical records upon which she's waived any privilege to, as well as under Rule 703, and that our expert should be allowed to rely upon the presence of marijuana in her system at or near the time of the crime, including the day after the offense, to render his opinions regarding her mental state at the time. We ask that the urine drug screen not be suppressed in its entirety, Your Honor.
All right. The court looked at several different cases, in particular Skinner, Von Raab, Vernonia, Maryland versus King. In addition, the court also read Chandler versus Miller and Ferguson versus City of Charleston. In this particular case, because the need for a warrant is greatly diminished here, where the arrestee was already in valid police custody for a serious offense supported by probable cause, the search is analyzed by reference to reasonableness not individualized suspicion. Reasonableness is determined by weighing the promotion of a legitimate governmental interest against the degree to which the search intrudes upon an individual's privacy. The court would find that the government has there's a legitimate governmental interest in determining whether or not somebody is under the influence in the juvenile detention center, not for the purposes of prosecution, but for the purposes of safety of the accused. Obviously, like Mr. Gerber testified, if somebody tested positive for fentanyl, there are serious withdrawal issues. Well documented. It's not hard to find that out there. I'm not sure the Juvenile Detention Center is equipped to handle those type of situations. There's a valid governmental reason to do it. Looking at Skinner, Von Rad, and Vernonia, the court believes that falls into that. Additionally, the court looked at Jones versus State, Mississippi case cited 881 Southern 2nd 209. The physician-patient privilege was waived in this particular case. And in Jones, the evidence was actually used to prosecute the person. That was not the intent of this evidence. The intent of this evidence was to find out whether or not there was a critical medical need that needed to be assessed at that moment. Now, the court would have a different holding if the state was attempting to offer this to prove possession of cannabinoids or some other crime, but that's not what it's being offered for. In retrospect, the state was able to go back and look at that and raise it for the defendant's insanity defense. So for those reasons, in the case law cited, Maryland versus King, the court would also find that a urine analysis is the least invasive and most reliable method to obtain a drug screen. A needle would be very invasive. Buccal swabs are not considered to be very reliable. The saliva type testing. Hair testing is invasive. You're removing a piece of hair from the child's body. And in addition, the reliability of those in short periods of time are not where they need to be, so to speak. It shows too great of a window. So for those reasons, the court is going to deny the motion to suppress. However, the court is going to restrict the state. You're not to get into this in your case in chief. It can only be used if and when the defendant raises their insanity defense. That'll be the court's rule in the states to give me an order. All right. Next matter was a motion for gag order document number 177. The response was filed late. As such, it will not be considered. Motion for gag order is granted. Give me an order. Next motion is document number 175. Motion to enforce the court's previous orders and compel a motion limiting to exclude evidence not previously discovered, produced in discovery. Again, the response was filed late. Document number 174. Motion limiting to exclude insanity defense, exclude testimony of Dr. Gerald O'Brien, Dr. Mark Webb, and Dr. Clark. Again, there was a late response filed. However, we're going to have to deal with the issue of late file discovery, so I want to hear it all at once. State's motion, I'll hear you out.
Court's indulgence, I'm trying to get it.
Getting that together. For the record, even though the responses were filed late and the others, I did read them before I granted the motion. All right, let's see.
And I'll start with our motion to enforce the court's previous orders to compel a motion limited to exclude evidence not previously produced in discovery. This court entered an order directing both parties to exchange discovery that was in their possession at that time by August the 20th 2024.
I think I actually ordered y'all to do it 2-3 times before.
That's correct, Your Honor. The last order regarding discovery said that all discovery within the party's possession, there was also an in-court hearing regarding that, was to be turned over or the possibility to be excluded.
All right, let's start.
So
What are you trying to exclude? Which witnesses?
Yes, sir, Your Honor. So as of August the 20th, 2024, the state had 0 witnesses from the defendant and or any substance of their testimony. So we filed this motion on August the 30th asking that pretty much any evidence that they sought to introduce at that point be excluded because we had received none. So to be clear, the defendant had dropped off an external hard drive, a jump drive at our office. It contained photographs. It contained an investigative journal by someone by the name of Amber Floyd. It did not contain anyone's testimony, anyone's information, and we were not provided the substance of anyone's testimony. During that same meeting, this was plea negotiations. The state had offered and asked, and quite frankly begged, for the names of anyone who would provide any information regarding the defendant's potential mental state at the time. We were not provided that information. However, the defense attorneys told us during that meeting that they knew the names of several teachers, as well as had a statement that the victim, the living victim in this case, Heath Smiley, had prepared, where they had sent him questions and he responded to those questions in writing, as well as other witnesses. We asked that that be turned over on that day. It was not. We've asked that it be turned over subsequent to that, and it was not until September the 3rd that the state received a list of witnesses from the defendant. And I apologize, Judge. May I get that?
You have a copy of it?
Yes, sir.
Of the list you received?
Yes, sir, Your Honor. On September the 3rd, the state was emailed a witness list that contained the name of Heath Smiley, stating that his proposed testimony would regard his personal knowledge and observation of the events on March the 19th, 2024, his relationship with Carly's mother, Carly's relationship with Heath, Ashley Smiley's mental and physical state, which we've been provided no documents to that effect, Carly's behavior and mental health issues from the fall of 2023 through the present. At this point, we still have not been provided any documentation, any statements, anything regarding any mental state other than the records that we've requested from 2023 outside of Mr. Smiley's interview with law enforcement on April the 4th that we provided. Additionally, it says that he will talk about the investigation in this matter by the Sheriff's Department as well as the Rankin County District Attorney's Office. Essentially, Vicki Breland has pretty much the exact same substance of testimony. That is the deceased victim, Ashley Smiley's mother. Next witness is James Daniel Floyd. He is the brother-in-law of the deceased victim, Ashley Smiley. We have no substance of his testimony other than he will testify regarding his personal knowledge and observations regarding the events on March the 19th, 2024, and the investigation by the Rankin County Sheriff's Office. No information provided by him other than that, with the exception of contact information. BG, who the state has interviewed, and SR, who the state has interviewed. Next, they list a Shira Higbee. It is believed that Ms. Higbee is a teacher and that this is one of the individuals, again, that the defendant knew about far in advance of August the 20th, as well as Tricia Gilbreth. Again, it appears to be a teacher of Carly's that the defendant knew about far in advance of August the 20th. The next name, Dr. Andrew Clark, which he was not retained before August the 20th, so of course that was not in their possession at the time. We have a separate motion regarding Mr. Clark. And then Corey Garber, which we do not object, of course, to the testimony that he provided. But certainly, so we're asking that any testimony that Mr. Smiley is called to testify about outside of the two statements that he's provided to law enforcement in this case be excluded. We ask that any testimony by Vicki Breland regarding anything at all be excluded, that the testimony of James Daniel Floyd regarding any type of testimony be excluded, that BG, anything outside of the interviews that he's provided to our office, be excluded, and those have been turned over to the defense, as well as SR. Same thing for her. Our office provided statements to them, recorded and typed up interview notes. And then we're asking that Shira Higbee, Tricia Gilbreth be excluded, and of course we asked separately that Dr. Andrew Clark be excluded. But those were all people that were in the possession of the defendant prior to August the 20th, 24. In addition to...
Hang on, before we leave that, do you have a copy of the witness list you present?
Yes, sir. May I approach?
Mark Eskin.
And Your Honor, for the record, I want to show it to them. I have the email where it was sent September the 3rd at 4:15 to our office. May I proceed? We, of course, outlined our arguments within our motion as to why we believe that those witnesses should be excluded. I mean, first and foremost, the fact that they violated this court's multiple orders regarding discovery, that by their own admission, they had this information and for whatever reason chose to wait till September the 3rd to produce it. There's no good reason other than willful conduct for them to have done such. There were multiple conversations between the state and the defense about turning over this information. This is not new information. This is not something that wasn't in their possession. This is something that we certainly believe is akin to a willful attempt to hide evidence. We ask that each of those witnesses, with the exception of Mr. Smiley, and the testimony that he's previously provided to law enforcement, be excluded. Would the court like for me to proceed with regards to our other motion in limine for the experts?
No. Any further argument as to these witnesses?
No, sir.
All right. I'll hear the response.
You know, we provided the state a witness list. I think it was sent over on the 3rd of September, if I remember, and I think that's what it was told to the court. I don't think the state is saying that they're surprised as far as any of the witnesses. I think what they're asking for is for the witnesses to be struck. I have brought some case law dealing with that issue for the court, if I may approach, Your Honor.
I'd like to see your case law.
Dealing with, when we're talking about witnesses being struck and everything, Your Honor, the issue of witnesses not being allowed to be used, it gets into the issue of surprise, whether or not the other side is being surprised. Most of the time, in all the case law, it is either in the middle of trial when that's taking place, or right on the eve of trial.
What about Page versus State?
Again, Your Honor, I'm not familiar with Page versus State.
Page versus State was 11 days before trial. The defendant provided a list of witnesses but did not provide the substance of their testimony. He made the exact same argument that you've made before this court in regards to an affirmative defense of alibi. And the Supreme Court said the court was right to strike it down and exclude it.
Well, my understanding of following in looking at the case law as far as, I guess, what has been provided and everything, most of the witnesses that we have are witnesses that we have gotten from the state.
Okay, the Supreme Court's also dealt with that. There is no exception. Under the defendant's requirement to disclose witnesses in Davis versus State, 9.04C1 clearly required the defendant to disclose the names and addresses of all witnesses in chief, which the defendant may offer at trial, together with a copy of any written or recorded statement or oral statement they were aware of, and the substance of any oral statement. The rule contains no exception for a witness who is referenced in materials that the state produced in discovery. So I will start here. This is your burden of proof. Show me what you produced as to Heath Smiley.
We don't have any written statements from Heath Smiley.
Did he give you any oral statements?
Just what the same thing that he's given to both sides. I mean, that's the...
Great, so all he'll be able to testify to is what was provided in the state's discovery, correct?
That's correct, Your Honor.
Okay, so he'll not be testifying to anything other than what he's testified to in open court or what he's given a statement of?
That's correct.
Okay. All right, that was pretty easy. Vicki Breeden, show me what you produced.
I think it's what has been proved. Has there been anything?
What's in the witness list?
It's what's on the witness list, Your Honor. There were no written statements from her.
It's not just written statements.
There was no.
And you practiced law here for 20 years. You know this. You know this. They told you something, you have to turn it over. So if Vicki Breeden said, hey, I knew A, B, C, D, she doesn't necessarily have to write it down. You have to tell them about it. Y'all show me what you produced. Is there anything else that you produced other than what's on S1?
No.
James Daniel Ford. Show me what was produced other than James Daniel Ford.
It would be the same, Your Honor. There's no written statements or anything. It'd be.
What about oral statements? Did he give an oral statement that would be relevant?
I'm sorry. Your Honor, Dr. Clark talked to Heath Smiley, and that is in Dr. Clark's report. So that has been furnished.
When? What day was that furnished?
On the 6th, I believe, Your Honor.
September?
September 6th.
17 days after the fourth discovery deadline the court did?
Yeah, it wasn't a conversation I had with Heath Smiley. That has, we're just bringing to the court's attention that those statements are in, Dr. Clark interviewed Heath Smiley. I was not present.
BG. What was produced in relation to BG?
I guess the same thing that is on the
All right. SB, SR.
Same thing? Same thing.
Sheriff Hickman.
Same thing, Your Honor.
Tricia Gilbert.
It's going to be the same thing.
Okay. Let's take Tricia Gilbert for example. And I understand your interest in Mr. Kemp. It seems that you didn't do the discovery.
I did not do this. I did not do this list. I have not talked to these witnesses. These witnesses, I'm dealing with other witnesses in other part of it, so I'm not familiar with it.
Okay, so let me ask you this. Even though the rule prohibits this, the court's going to require two attorneys to respond to this, okay? So I'll let Ms. Todd take this, all right? Is that fair? Did Ms. Todd deal with these witnesses?
Yes, sir.
Okay, thanks.
Your Honor, I would.
Hold on just a second. As to Tricia Gilbreath, what did you turn over?
Your Honor, during a session I had in the DA's office with Ms. Newman and Ryan Berry, I relayed to them that the oral statements that the teachers had made to me during that session. In fact, it was even referenced. In their expert report, which we got last night at 6:30 p.m. Our expert report.
We'll get to that.
Yes, sir. Our expert
So
report.
what do you have, other than your word, that you gave these statements to the state?
Well, Your Honor, I didn't record my conversations with the state, but I also told the state during the documents that she's talking about is my direct examination. They asked me if I had any written statements for any witnesses,
That's
and I
not
said,
what the rule says. Did you speak to Tricia Gilbreath?
briefly, Your Honor,
What did Tricia Gilbreath tell you she's going to testify to?
she's going to testify to what exactly I told the state she was going to testify to.
No, you tell me. I have to make
Yes, Your
I'm
Honor.
making a decision.
She's going to testify that she was one of the last teachers that saw Carly on the day she left the courtroom, and that Carly did
Where's
not
that
seem
at?
angry.
Where's that?
Your Honor, I don't have the witness list in front of me, but I believe it says in the witness list. Thank you, Your Honor. Your Honor, in the witness list, it says that she will be regarding her personal knowledge and observations from Carly from the fall of 2023 to March 19th. Carly's behavior and demeanor during the fall of 2023 to March 19th, 2023, based on her personal knowledge of Carly's relationship with her mother, Carly's personality, and her relationship with Heath Smiley, and Carly's performance in her classroom. That's exactly what she's going to testify to. And the reason we took it back to the fall is it shows you that she's had Carly in her room for that long. She knows what she's like.
So what did she tell you that you intend to elicit?
I just intend to elicit that when Carly left the classroom that day, she did not notice anything that seemed Carly was upset, that Carly was angry, or that Carly had anything but a positive relationship with her mom.
Where is that in there?
Your Honor, the state sent us the same stuff in their witness list. I had this conversation with the state in person. I didn't feel the need to write it all out again.
Okay. So you don't have any proof other than what you say as to Tricia Gilbert,
I mean, I could call Ryan Berry if I needed to, but no, Your Honor.
He's a lawyer, he's not a witness.
Well,
But if you feel the need to, I'm not going to stop you. But that's not, how's that relevant? How's what you just said relevant? That she seemed fine when she left school that day?
Well, Your Honor, I think it goes to Carly's demeanor, Carly's personality, and it will go into what...
State have any objection to a teacher saying that she seemed fine when she left school that day?
Your Honor, if that's what she wants to elicit from that teacher, and that's her only testimony, that she seemed fine and she had a great relationship with her mother, we would love for them to call her as a witness.
All right, nothing other than that.
That's
Let's
right.
go to the next witness.
Okay.
Next witness.
Andrew Clark.
No. Going in reverse order. We'll go into expert second.
Sheer Higby. Same thing.
Okay. Show the court what you turned over in relation to Sheriff.
The same thing that's listed here, that she anticipates that she'll testify regarding her personal observations in Carly from the fall of 2023 to March 19th of 2024, Carly's behavior and demeanor from the fall of 2023 to March 19th of 2024, her relationship with her mother, Carly's overall personality and performance in her classroom.
All right. Well, what's she going to testify to about the relationship?
Exact same thing to what the other teacher will testify to.
Well, let's articulate it clearly.
Okay, to articulate it clearly, Your Honor, she'll be testifying to that she's known Carly and had Carly in her classroom for the better part of a year during the 2023-2024 school year. She saw Carly on the day of March 19th, that she has known Carly and her mom for quite some time, that Carly is a good student, a good kid, not a troublemaker, not a troubled kid, and that...
That's a lot of character evidence for what particular pertinent trait?
Your Honor, I think it goes to what the state will be trying to introduce as Carly having some troubled
some troubled child with a history of violence, which is just not true.
State have any objection to the witness testifying that that witness taught her that year, she saw her on that day, that she's a good student, a good kid, not a troublemaker, not a troubled kid?
I think the last part we would object to until after Ms. Gregg testifies, and then she can put on her character witnesses. But as far as her observations of Ms. Gregg on that day, that she was not, didn't seem in distress or abnormal, and that she had a good relationship with her mom, we do not object to that testimony, Your Honor.
All right. Court will allow that testimony and that testimony only until we get to character witness testimony. Who's the next witness on your list?
The next witness on our list is SR, followed by BG. These witnesses are the same witnesses the states are going to call, and we're calling them for the same reasons, Your Honor.
Okay. So you didn't turn anything else over? No statements from the juvenile witnesses, correct?
I haven't even spoken to SR. So
What about BG?
BG spoke to him briefly, but the testimony is the same thing that the state recorded in their interviews.
All right. And they won't be allowed to testify to anything other than what's in the state's interviews. As the court pointed you to the case law, there is no exception to the discovery requirement for the defendant just because they're listed in the discovery by the state. So you can't elicit anything that's not in their report.
Wasn't planning to.
All right. Who's the next witness?
The next witness is James Daniel Floyd.
All right. Show me what you turned over in relation to Mr. James Daniel.
Your Honor, the only thing we're anticipating calling Mr. Floyd about is just what he saw on the day of the investigations. I have not had personal conversations with Mr. Floyd. He's just going to confirm the demeanor of Mr. Smiley during the investigations when the police were at the house.
How's that go?
I think it will be relevant to the case in chief when we start talking about the investigation that's going on and cross-examination with the state.
Well, I thought he's not testifying to the investigation. What's he going to testify to about the investigation?
Your Honor, I feel like talking about this now is somehow going to prejudice Carly with the jury, so I'd rather...
Ms. Todd, you can't hide evidence. You can't go to trial and them not know what the witness is going to say. This is basic 101 law. Mr. Kent, can you cite me a single case, one, where a defendant got to go to trial and not tell them what the other side is going to say?
I definitely agree. We have to turn over our evidence to you.
And we're late. We're real late. Who is James Gilbert? I'm sorry, what was the name of the witness?
James Floyd?
Yeah, who's that?
Carly's maternal uncle.
Excluded. That's excluded. That's excluded as a willful discovery violation. That statement right there, there's nothing that's been turned over of any substance. Excluded. Next witness.
Next witness is Vicki Breland, the maternal grandmother. And it's going to go to the statements she made, not to me, but to the statements she made to the expert witness, Dr. Clark, regarding the family's mental health history.
When was that turned over?
That was turned over on the 3rd, Your Honor. We got the state's expert witness report last night at 6 p.m.
You complaining about the state's rebuttal witness to your witness is a bit like a lady standing in the street holding a Christmas and screaming she's hungry. You were ordered to turn over an expert witness July 28th. You told me it'd be July 22nd. After the discovery deadline passed, we had a new expert witness was hired. So you juxtaposing what they've done with what you've done. Bottom line, what did you turn over to them? Show me what you turned over to them in relation to Brown.
The relationship would be the statements made to Dr. Clark, Your Honor.
That's in Dr. Clark's report.
And again, Your Honor, both the state and the defense had to retain new experts after the discovery deadline was passed.
Now, the state's expert was retained before.
the state's expert in being Dr.
Well, the state retained Dr. Gugliano. You instructed the defendant to plead to assert her Fifth Amendment rights during that conversation.
No, we didn't, Your Honor. She
It
didn't.
says so in Dr. Gugliano's report.
2-1 question.
And then I just got finished reading some of Dr. Pickett's report, and we're going to get to that. We're going to get to that. But let's stick with the grandmother and what she did. If you want to take shots at them on the expert witness, we'll do that. Show me what you turned over in relation to the grandmother before August 20th.
Your Honor, we didn't have anything for the grandmother before August 20th. That only occurred after the report we received from Dr. Clark, in which Dr. Clark spoke with the grandmother.
You're representing that you had no conversations with this defendant's grandmother.
Not to the nature of anything with the case. We have discussed the trial in general and explained the trial process, Your Honor. We have talked about how Carly's doing, but not anything that would go to testimony that she would put on at trial.
All right. Before we move on from that one, I want to hear a response from the state. Does the state have the opportunity to speak with her?
Your Honor, no, and I'm looking at Dr. Clark's report. There's no mention of an interview or discussion with Vicki Breland. If they could point me to where in the report it says he relied upon
Dr. Clark's report? You have a copy of Dr. Clark's report?
I don't have it with me, Your Honor, but he did have a
Let's go get
conversation
it.
with Ms.
Go get it. We can move on to the next.
I mean,
I can't talk about Dr. Clark's report if you don't have a copy of it.
Would you like me to proceed with Mr. Smiley until we can?
Sure.
Okay. Same thing with Smiley. He has given a statement in which was listed in Dr. Clark's report as a 90-minute Zoom conference call. He has done a witness interview, which we received from the state, and several just with the body camera footage of things that happened on March 19th. That's what we're calling him to talk about.
Smiley's testimony will be limited to the matters turned over before August 20th.
Your Honor, I would also cite that Mr. Smiley testified before this court, and we have that transcript on June 4th. The state has that, so we intend to elicit the same testimony at trial that we elicited on June 4th.
And you're allowed to do that, I said before August 20th.
Perfect.
I said before August 20th. All right, is that everybody on the list?
Yes, Your Honor.
All right, if you would return the court's exhibit. And while we move to Mr. Camp, I assume you're handling the expert witnesses. Is that what's your?
Yes, Your Honor.
All right. Ms. Todd, I think your office is across the street. Can you go get a copy of Dr. Clark's report?
Well, if the state has it, I can reference it right
Yeah,
here.
mine has writing on it, Your Honor. I don't have a clean copy of their
I need
report.
a plain copy of Dr. Clark's report, please. Somebody.
That's not his report.
It's hard for us to proceed without a copy of the report. You'll need a few minutes to go get a copy of the report.
Yes, I didn't bring a copy of his report with me today.
I can't really address what the grandmother or Keith Smiley said without seeing Dr. Clark. So let's take is there another motion we can handle while somebody gets a copy of them? Either one of you. I mean, there's two lawyers. I don't care.
Get a copy of that?
Yeah.
Okay.
Well, Your Honor, I don't think the court has yet ruled on the state's motions that we did timely file, in which we also asked that the state not be allowed to make speaking objections. We also asked that the state.
I didn't see that. I did rule on the speaking objections.
Your Honor, our motions were so good, they filed the same ones. As to the
They're
speaking
granted.
objection. And
Thank you, Your
They're
Honor.
granted. I didn't see those. They're granted. Do we have any other motions we can hear before somebody can get me a copy of Dr. Clark's report?
We can do we have our cursory motion to move it down to the youth court that we filed sometime before.
I'll be happy to hear that. Can we work on getting Dr. Clark's reports? Somebody, anybody?
Yeah.
Your Honor, may I address briefly the substance and just cite the court to the attachment that I filed, which shows that we were missing each statement, the teacher's names and substance of their testimony, Dr. Webb's report, and potentially a journal of Ashley. That was on August the 20th when we signed for it, so they knew at that time that we did not have the teacher's names or the substance of their testimony.
Is there an alleged journal of Ashley Smiley?
We do not have a journal of Ashley Smiley.
Does anybody have a letter journal from Ashley Smiley?
I don't think my understanding, we don't have it. We do not have
Where
it.
did that come from in Dr. Pickett's report? I've been able to read about 17 pages of Dr. Pickett's report. He references the journal of Ashley Smiley. Who gave him, I don't think Dr. Pickett just made up a journal, did he?
We didn't provide Dr. Pickett with anything, so if he's, that would have been something that the state gave him. That's not.
All right, let's take a 15-minute recess. Y'all go get Dr. Clark.
14-year-old Carly Gregg was a really good student. In fact, she was Student of the Year at Northwest Rankin High School in Brandon, Mississippi. Carly's mom, Ashley Smiley, was a teacher at the school. Now, for most moms, this would be an ideal situation, being close to your child who is excelling in school. But inside their home and inside the mind of Carly Gregg, everything wasn't okay. She was battling serious issues that seemingly manifested themselves one day inside their home. Carly allegedly armed herself with a gun and confronted her mother. She discharged that weapon 3 times, taking her mother's life. Then, in a bizarre twist, she allegedly contacted a friend to come over and showed her the dead body. Then, when her stepfather returned home, she fired the gun again, wounding him. He survived, and today he took the stand in Carly's murder trial. And we are live from Mississippi with all the latest.
I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. A big hour ahead, 2 really, really big stories. We begin with Carly Gregg, who was just 14 years old. 14 years old. Think about that age. Think about your children when they were 14. Think about yourself when you were 14, what life was like, what life was about. What are your concerns? What's going on? Was it a difficult time for you? Was it a difficult time for your kids? Clearly a difficult time for Carly Gregg. Something really wrong was going on inside of her mind. Really wrong. The question is, obviously for this jury, was it criminal what was happening inside her mind? Now, we saw her in court yesterday, and she was an absolute mess listening to the 911 call. And in those moments when you look at her, she looks like a young girl. She's only 15 at this point, but actually appears younger than that age. So you look at this child in court crying, a complete mess, and you think, wow, like, this really has done a number on her. Like, she's somewhere else. But then you contrast that level of despair, whatever it was that we saw yesterday in court, and you compare that to what we see in the video from the day of the shootings. And she's caught on camera, and it's not that same level of crying, despair, and emotion. Looks more like you're trying to do something and get away with it. I mean, that's what it looked like. So this is some of the evidence in this case, because obviously they're not going to say she didn't do it. What they're saying is, okay, she's 14 and she's got a lot of issues. But this isn't criminal behavior because of her state of mind, lack of maturity, mental disease or defect, whatever's going on with her. She wasn't able to really understand and apprehend the nature of what she was doing. But you'll see the video from the day. The stepfather who survived this, miraculously, I don't know how, but he survived this, some gut-wrenching testimony from him about what happened, about what is going on, and everything that he's been through and this family has been through. His wife shot and killed and murdered, gone. But he survived it, so he's got to deal with that. And then he's got a stepdaughter. And, you know, you could say the word step, but he stepped into the shoes of being her father. And she's alive, but she tried to kill me, and she killed her mother, my wife. How do you process all of that? It's not easy. Not easy at all. Heath Smiley is his name. Let's take a listen to some of his testimony.
Tell the ladies and gentlemen exactly what you remember about when you came home on March the 19th, 2024.
Everything seemed pretty normal, and came on in, and when I opened the door to the kitchen there, gun went off in my face before the door was, I don't know, 3 or 4 inches wide open. And everything kind of went pretty fast from there. It was a blur. Gun flash in my face, and then it went off 2 more times, but my hand was on the gun after the first shot, and I twisted it from her.
Who was pointing that gun at you?
It was Carly.
Who pulled the trigger when you opened the door?
The first one I know was Carly. After that, my hand was on the gun too, and I know I had a scratch on my thumb and all. I very well could have hit it. I know that third time.
Did you ever get struck by a bullet?
Yes, one of them kind of grazed right through this muscle up here.
Can you tell ladies and gentlemen what did that feel like?
I know this sounds weird, but I honestly have never felt it to this day. She was screaming out of her mind, scared. It was like she had seen a demon or something. She was terrified. And my first thought was there was an intruder somewhere, and she thought she was after somebody else.
And to be clear, Carly never told you that she thought somebody else was in the house, right?
No, that's the feeling that I got. She was terrified out of her mind.
He survived. Somehow, some way, he survived all of that. She'd saved 3 bullets for him, but he was able to wrestle that gun away from her. All right, let's bring in our guest. Joining us tonight to help break down this case, Court TV legal correspondent Kelly Craft, who's been inside that courtroom today. Kelly, great to see you. Thanks so much. Wow, what a day. Incredible emotion and the reality of what actually happened there. What did the stepfather, Heath, say about finding Ashley?
Good evening to you, Vinny. Really compelling testimony when Heath Smiley was on the stand. And I just want to describe this courthouse. So behind me, you can see the courthouse, very small. Inside, only 3 courtrooms. And so when Carly Gregg ends up walking in, some relatives of hers, they're in the front row of the gallery, and they always do some exchanges, kind of smile at one another. And then when her stepfather was on the stand, he was asked to identify the person who shot him, and he said Carly Gregg, his stepdaughter. And when he did so, they both smiled at one another. This was as he was then proceeding to talk about how he discovered his wife being dead, and he had looked all throughout the house, and the last place that he looked was his stepdaughter's bedroom, and that's where he found his wife. Let's listen to some of that testimony.
Checked our bedroom, bathroom, closet, other side of the bed, under the desk in there, and turned and started going towards the other end of the house. And I glanced in our spare little 3rd bedroom, and then turned and went into Carly's room. And that's where I found Ashley.
When you found Ashley, can you tell the ladies and gentlemen what you saw?
She was laying on her back and had her hands kind of across her, and a towel over her face.
Do you remember what color the towel was?
I do not.
When you saw her laying there, what's the very next thing that you did?
Checked her pulse and see, and kind of moved the towel, and then called 911.
So, Vinny, you could just hear it in his voice. Just really hard for him to recall all of those events that day, which obviously turned out to be an extremely tragic day for him.
Hey, the shock at the door and then trying to figure out what's going on and then searching desperately for his wife and then finding her that way. Let's talk about the home security footage, because I think this is an important piece of testimony or piece of evidence for this jury.
It is, Vinny, and when you mentioned at the beginning talking about her being a young woman, so 14, 15 years old now, so a teenager, inside this courtroom, when she walks in and when I see her, she does look like just this little girl, and you think, how could this have happened? She does look like a little girl. Her stepfather described her as a sweet little girl. This is after that she attempted to kill him as well, tried to kill him. And so this surveillance video that they ended up showing in court, you see a very different person. You don't even see the same person that's walking into the courtroom. You see a different girl that looks like you see her kind of hiding behind some walls, watching what her mother's doing. So why don't we go ahead and play this? We're going to play two. The first one is when the stepfather is coming home. You can see him come out of his car. This is when, so Ashley and her mom, they're at the same school. Her mother's a teacher at the school. And this is them coming home. And eventually you're going to see Carly Gregg. She's gathering some things out of the car from school, maybe a backpack. You can't really see the items, but just gathering some things out of the vehicle. Eventually you do see her stepfather pull up. Now, what it appears from the evidence, that's her stepfather pulling up. Carly had texted her stepfather, pretending to be the mother, saying, honey, when are you going to be home? And this was from the mother's phone. This is what the testimony indicates, that it was Carly that did the texting. So you see the stepfather. He's going to eventually make his way into the garage, and then he makes his way into the kitchen, and then the video captures the sound. It captures the gunshots and the screaming. And then that's when you see Carly running away, as well as that friend who was running behind Carly. And that's the friend that Carly had called over to ask her if she's ever seen a dead body. And so that was one of the videos that was played while Heath Smiley was on the stand. And then another video was played when an investigator was on the stand. And this one was really hard to watch. A lot of people were gathering around in the back to watch one of the monitors. The jurors had a monitor in front of them, and they were watching. And I could tell even one of the gentlemen, he was wiping away some tears, because you know what's about to come. Why don't we go ahead and play that video? I want to say, you don't see the shooting, you hear the sound, but knowing what's going to come, it is kind of hard to watch. I want to give that warning. Let's watch that. So that video was played for the jurors in court today, capturing the sound of when Carly Gregg ended up shooting and killing her mother. And then you saw her there. What a investigator said on the stand, it appeared that she knew that she was being recorded. This is what the investigator on the stand said, because you couldn't see what was behind her back. And the investigator is saying that there's something behind her back, and then she set something down, which sounds like it was the gun. But defense counsel was quick to point out, we never saw the gun right there, but the state said it did sound like it, and the investigator said that as well, Vinny. So hard video to watch, a very tough time in the courtroom today watching this.
You hear the crying in the background. She grabs it again. Looks like she's going back in there to the room. Sounds like the mother is still making noise, was still alive. She's texting calmly from the kitchen, and the dogs sort of just follow her. This, I mean, it's obvious that she's hiding something behind her back, that she knows the camera's there.
She knows the camera's there, and even before some of the clips before this, you saw Carly kind of walking in and out of the house. You saw the mother going in and out of the refrigerator. Kind of, I don't know, it seems as if maybe she was looking for Carly. I don't really know. There was some testimony that Carly, it appears, maybe got in trouble that day at school for something, maybe possibly with a cell phone. So who knows exactly what took place. But yes, then the surveillance video does show Carly and shows her kind of looking around the corner and then going in there after a mom and then hearing the screams and then going back in there again, Vinny.
The calm demeanor afterwards is the most chilling part to me. All right, let's get back to Heath Smiley. What did he say about the family dynamics inside that home?
Vinny, and this was interesting testimony to listen to, because he was asked on direct examination, did she ever get into any trouble? Did she do anything wrong? And he did mention a few times. He said, one, there was a knife that she did bring to school. So he mentioned that, and then she had to go to an alternative school after that because the school had a zero tolerance for that. Then there was just another time when there was some cheating with some kind of test, but everyone was testifying, including Heath, that she was a genius, well beyond her years in regards to her intelligence. And really, she just got tired of other students asking her for answers or help with their homework. And so it appears one time she took a photograph of a test that was opened and maybe shared it with some other students. And so then that was labeled as cheating. But that was about the extent of bad incidents that he talked about. He really said they had a great relationship and they still communicate now every day. Why don't we go ahead and listen to that testimony?
Do you and Carly still have a relationship?
Yes, I think we're good.
Okay. And how frequently do you and Carly talk?
Just about every day now. I don't always get off of work in time to catch her on a phone call, but we text some back and forth over the app that's allowed, and we talk over the video chat thing that's allowed through the jail and on weekends. So we're good.
So, Vinny, it's hard to imagine, but you heard it right from his mouth there, that they have a good relationship right now. And again, as I mentioned in the beginning, he describes her as just a sweet little girl.
Kelly Craft in Mississippi tonight. Thank you so much. Excellent reporting, as always. Okay, let's get a little more analysis of all this. Joining me tonight, forensic psychiatrist, trial expert, witness columnist, Dr. Carol Lieberman. Dr. Lieberman, I want to follow up on what we just heard, where the stepfather and Carly speak almost every day. Is that healthy? Is that healthy for him? Is that healthy for her?
Yes. I mean, you know, she needs him, of course, more than he needs her right now. But you could really tell that there was a sincere, authentic kind of communication between the two of them, where there had been, you know, this love, this close relationship. You know, his testimony was one sort of psychological bomb after another. Not a bomb in a bad way, but just these things that give you insight into her. And And it was, it was pieces of a puzzle, like a big jigsaw puzzle where each little bomb would land, in a different place on the puzzle. And it's starting to put the picture together. Of course, her biological father is one of the biggest missing pieces. I don't know if he's going to be testifying, but it seems to me that he needs to. We need to know more details about him.
And what about that surveillance video where we see her very calm? She shoots her mother, then very calmly comes back in the kitchen, hiding the gun from the camera, and then sends a text message out. We believe the text message was likely to her stepfather to have him come home to the house so he could shoot her. So she could shoot him.
Shoot him. Yes, that part is a little chilling. In terms of not guilty by reason of insanity, it's certainly, she certainly seems like, I don't know, it is more chilling. I mean, I go back and forth with thinking that she is, really, she would meet not guilty by reason of insanity. And then on the other hand, I think there are some things, well, what's the most interesting, the biggest part of what he testified about that makes the most sense in terms of explaining things is how her mother and her biological mother and father had another child, a daughter, who died from some genetic disorder. And that this was probably what made her mother become more protective, overprotective of Carly. And the difference between what it was like in her house with her mother and stepfather compared to what it was with her biological father, and she was apparently going back and forth, and her mother was trying to decrease the visitation with the biological father, but it was like two completely different worlds. She said her biological father had drugs all around the house. He was using drugs all the time. He was blowing smoke in her face from smoking drugs. He got her, I guess, to drink an entire beer when she was 12. I mean, we're going from a drug den, essentially, on the one hand, to a mother who, I think was rather overprotective, a little too much, even though we can understand why, that she didn't want her to die or to have any problems like her other daughter. But that was crazy making, and I think part of her, even though the stepfather said that both Carly and her mother were terrified in talking about the biological father. But at the same time, I think she had some desire to be with him.
We're out of time for tonight. Dr. Carol Lieberman, thank you so much. When we come back, we'll bring in our think tank, Plus, coming up next hour.
Tonight on Vinnie Politan investigates the big story of the day. Hip-hop mogul Sean Diddy Combs arrested by law enforcement and indicted by a federal grand jury. What was going on at Diddy's freak-off parties? We investigate.
Join Court TV's Vinnie Politan.
In every story, in every trial, every case, there's at least two sides to it.
To dive into the latest.
Oh my God.
And breaking true crime stories.
This was a very targeted, very personal attack.
Inside.
I've never seen that in Discovery. I've been incarcerated 3 years.
And outside of the courtroom.
She's a psychopath.
Now, let's look at the other side of all of that.
Vinnie Politan investigates. Tonight, 9/8 Central. Only on Court TV.
Around the time that y'all found the iPod and Carly was cutting her thighs, is that about the same time that Ashley took her for therapy for anxiety and stress?
Within, I don't know, I think that was maybe a couple months maybe before, it seems like.
Is that your understanding, though? That's what you told law enforcement of why Carly was in therapy, was anxiety and stress?
Yes, ma'am, it was something like that. I think she was kind of depressed some days.
That's Heath Smiley, the stepfather who was shot, survived, shot by Carly Gregg, his stepdaughter. She's on trial. Her mental state is front and center in this case. It's what it's all about. Let's listen to more of his testimony talking about what sort of issues that Carly Gregg was dealing with.
Had you ever seen Carly be violent?
No.
Had there ever been any incidents in which Carly was in trouble for being violent?
No, not that I know of.
Okay. Had you ever seen Carly enraged?
No.
Had you ever seen Carly get mad?
No, she'd get frustrated with something every now and then if she couldn't make something work like she wanted to, or something in a video game, but she would work at it over and over and over till she figured it out and got it.
What, if any, issues had you and Ashley been having with Carly?
Just not really any problems with her, other than I think she was kind of at times depressed, or she's a teenage girl, maybe emotional, but she ended up, we got her to a clinic up close to her, I guess it's in Madison there, to let her talk with a therapist.
Okay, and what had led you and Ashley to decide to put Carly in counseling?
She just didn't seem like she was her normal happy, peppy self. She was just kind of depressed and sitting around more, and she, she said she thought talking to somebody might help her.
Are you aware of any medication Carly had been placed on?
And I can't remember the names of which one was which. She had been placed on one by the therapist that they had started her on something.
And do you recall what that medication was for?
Whatever they thought it was, whether it was, I don't know, just generalized stress or depression, or I don't know what they were thinking it was.
Okay. And do you recall how many medications that she'd been on?
I know she was on one, and then approximately the week before the 19th, they swapped her to another one.
Okay. And with the first medication that Carly was on, did you notice any changes in her personality or demeanor?
No.
And with the second medication that Carly was on, did you notice any changes in her personality or demeanor?
No. She had only had a chance to be on it for a handful of days. I don't know exactly how many days, but she was just getting started on it.
So she was dealing with some mental health issues, was medicated, and had just changed her medication. Does that explain this? Is that enough in this case for the defense? Let's bring in our think tank. Joining us tonight, trial attorney, fellow of the American College Trial Lawyers, Ann Bremner. Also with us, trial attorney Rick King and criminal defense attorney Ian Friedman. Great to see everyone tonight. Ann, what are your thoughts about this? She is apparently medicated, and if just a few days before all this happens, switches that medication.
I don't think it's going to be enough. I mean, she's going to be presumed able at least to commit a crime, and then you're looking at an insanity defense. I mean, she knew what she was doing, the nature and quality of her act, and she was not apparently suffering from, severe mental disease or defect. I mean, both of those things are going to be on her side to have to prove. But, geez, what a horrible case when you watch that home surveillance of her shooting her mom so coldly. And like you said, what was most chilling is the way that she acted right afterwards. Just got right on her phone and started texting a friend. I'm sure it said, "Have you ever seen a dead body?"
Yeah, Rick, you watch this part of the video. This is after the shooting has just happened. What does it tell you, and is there any argument that you can make based on this video to a jury that, hey, yeah, she's out of her right mind here. He doesn't know right from wrong. She doesn't appreciate the wrongfulness of what she's just done.
I mean, I think I take all the things that you and Ann just talked about, the callousness with which she appears to be acting here, the calmness that she has, and I wrote it down because I didn't know that fact that she had just switched medications within a few days. And when he said that, I wrote that down. I was like, if that's my case, man, I'm going through that medication. I'm trying to find out what the side effects are, and I'm trying to make hay out of that. To me, that sounds like something that a defense lawyer could work with.
You know, Ian, the jury's listening to Heath Smiley, her stepfather, who's living in that house with her, knows her better than anyone else in that courtroom, and he was shocked. Like, this was out of left field for him. So what are your thoughts about the changed medication? Is that Is that the key to the defense trying to explain what happened here?
Yeah, I mean, I think the stepfather brings it right up to the door. He was a great witness for the jury to hear. All of a sudden, she's perfectly fine. No outbursts, nothing, beyond what you would expect from a teenager. No problems, no violence, no this, no that, until, there's the word, until she switches this medication. And as soon as she switches it, days later, just as Rick was saying, days later, this behavior happens. So he's exactly right. This client is exactly, or these facts are exactly where we would hone in on those medications to determine what the effects were. Was she weaned off the other medications properly? Was this the right med? So this entire case right now, the defense is going to focus on what's going on right in here. There's a couple, the facts of the case, how she appears on the tape doesn't look good. She's got going for her age. As we know, jurors want to believe that there's something wrong with a young person who would commit something like this. It's now what the experts are going to say was going on with those medications and how it counteracted with her head.
And do you think the jury adopts any of the sympathy that Heath Smiley seemingly has? That, like, he speaks to her every day. They exchanged a smile in the courtroom. Does that open the door for the jury to say, okay, the victim is good with her, and the victim understands that wasn't really her?
I thought that was so compelling. I think that's going to be a great piece for the defense. That smile they exchanged. He's your dad. He stepped in as dad, and he loves her obviously. And he's telling the jury, this isn't the child that I was raising. Something snapped, something happened. Maybe it's the medication, but this just wasn't the one. That's nice, kind girl, great student, great child, great daughter to me. I think that's going to be huge for the jury.
All right, Rick, I'm going to give you a lot of power right now. Your last name is King, by the way. If you could wave your wand here and you deliver justice here, what would be justice in this situation given all of these facts? Not an easy one. She's 14. We've seen the video, the medication, the age, the victim's testimony. What's justice here?
Vinny, I don't know what my magic wand would want to do in this case. I'll be honest, this is tough. There's a woman, a wonderful woman by all accounts, who's dead, and we know who did it. Now, as a I guess in my own person, I am reluctant to throw children away. Because we always say they lack if Mike was here, they lack the mental capacity for all these decisions that we say that they can't make. And now here we are throwing her away for the rest of her life because of something that she probably, by all accounts, might be as a result of a medication change. That's a difficult call for me. If you're asking me to wave the wand.
I know, it's tough. That's why I asked you, because this one has a lot of folks, they're angry, but then they hear this other part, and then Heath Smiley testifies.
I want to talk to you about, tell the ladies and gentlemen, Heath, and I know it's probably difficult, you can take as much time as you need. Tell the ladies and gentlemen exactly what you remember about when you came home on March the 19th, 2024.
Everything seemed pretty normal, and came on in, and when I opened the door to the kitchen there, gun went off in my face before the door was, I don't know, 3 or 4 inches wide open, and everything kind of went pretty fast from there. It was a blur. So.
I want to take you back just a step. Yesterday, ladies and gentlemen, saw a bit of a video from inside your house, but just so we're clear, when you say you were coming into the kitchen, I believe you pull into the garage and there's a door that leads from the garage into the home.
Yes.
And then there's a little laundry room area.
Yes.
And then there's another door kind of beside your refrigerator that leads from the laundry room into the kitchen area.
Yes.
Were you coming in the first door or the second door when the gun went off?
The second door from the laundry room to the kitchen.
And do you remember, is there anything you do every day when you come in the house?
Usually stop and take my shoes off there and come on in and change clothes.
Do you remember if you took your shoes off on March the 19th?
I think I did, yeah.
Was it unusual for that second door to be closed in your house?
Sometimes it was, sometimes it wasn't. We would shut that door a lot of times, trying to keep the sound of the washer and dryer down, or trying to keep one of the dogs out of the garbage can that we had in there.
I have to do something similar. Y'all have two large dogs, right?
2 golden retrievers.
And so on that day, the second door was what was closed.
Yes.
I believe you said that you didn't get it open probably 3 or 5 inches before it went off. What did you remember seeing, Heath?
Just gun flash in my face, and then it went off 2 more times, but my hand was on the gun after the first shot, and I twisted it from her.
Who was pointing that gun at you?
It was Carly.
Who pulled the trigger when you opened the door?
The first one I know was Carly. After that, my hand was on the gun too, and I know I had a scratch on my thumb and all. I very well could have hit it, I know, that third time.
How close, Heath, was that gun to your face when that went off?
Maybe a foot.
Did you ever get struck by a bullet?
Yes, one of them kind of grazed right through this muscle up here.
Can you tell, ladies and gentlemen, what did that feel like?
I know this sounds weird, but I honestly have never felt it to this day.
When the gun went off in your face, tell ladies and gentlemen, I mean, was your body in a state of shock?
Not at that moment. I was trying to figure out what was going on.
Did you see anybody inside your home other than Carly?
No.
Walk us through, you said that you were able to at some point get the gun from her. Tell us, Heath, what is it that you remember after that?
She was screaming out of her mind, scared. It was like she had seen a demon or something. She was terrified. And my first thought was there was an intruder somewhere, and she thought she was after somebody else.
And to be clear, Carly never told you that she thought somebody else was in the house, right?
No, that's the feeling that I got. She was terrified out of her mind.
And at that time, you did not yet know that your wife was dead, right?
No, not at that time.
So Carly's scared. She's screaming when she shoots at you. How many shots went off from that gun?
At that time, there was 3.
What type of gun was it that you took from Carly?
It was my Taurus revolver.
And what type of what caliber of weapon is that?
So the gun is a .357 Magnum, but I think it had 38 special rounds in it. You can, if the gun's a .357, it can also shoot 38s. A little bit lighter recoil.
And what color was that gun?
It's just the gun matte silver.
Prior to taking it out of Carly's hand, where was the last time you saw that gun?
Ashley kept it on her side of the bed. So it had been there for probably a couple years.
When you say on her side of the bed, was it on a nightstand or was it somewhere else?
I think she kept it, we had like little cubbies underneath the edge of the bed. The mattress is sitting up on, I think it was sitting up under there.
Between the mattress and the cubbies, like
Well, I
underneath
think
the
it was
mattress?
just, I think she just had it in a cubby under there.
Was the gun just loose, or was it in some sort of holster the last time you saw it?
I do not recall that. It was a while back. It had been sitting for a long time.
Did you have other guns in the house on that day?
Yes, I had an old shotgun that I've had for years that's unloaded in the closet, and I had an AR that I had gotten, it was also unloaded in the closet.
Were there some other guns, maybe in a safe too, somewhere?
There was a Glock in the safe.
Oh.
There was a BB gun probably in the house somewhere too, I don't know.
Do you know if Carly knew the location of any of those guns?
She probably knew about the two in the closet, but like I said, they were unloaded, and the last time I had tried to talk her into shooting, she was too little to even hold them up. They're heavy, big.
And you had several guns in your house. Did you and Ashley ever go shoot guns?
Yes, we did.
That was something y'all enjoyed doing together?
Yes.
When you took the gun out of Carly's hand, what did you do with the gun?
I was holding on to it, and like I said, I, at that time, thought there might be someone else in the house, like an intruder or something, so I immediately started checking the house and looking for Ashley.
Did you attempt to call Ashley also?
I did.
I want to take just a step back, Heath. You get the gun from Carly. You said that she was screaming. What did she do next?
She fell back into the kitchen island, just kind of straight back onto her butt, and was screaming, jumped up, ran out the back door, and I mean, I'm still pretty quick and agile, but I knew I couldn't catch her. She was moving so fast. She ran out the back and took off, and I knew I wasn't going to be able to catch her, so I turned around, stepped back in, and I locked the back door behind me.
Do you know why you locked the back door?
Because I was thinking there might be someone else out and about and around, in or out of the house, so I went through checking the house.
Do you remember telling anybody that you were in such shock that you didn't even try to shoot Carly back or anything like that?
No, it was very evident to me immediately that something was very, very off with Carly. The way she was screaming, the way she looked, she was moving so fast.
So, Heath, you said Carly is at this point, she's out of the house, she's run off. You never actually saw someone, other than Carly at the house, right?
No.
So you locked the back door, you're going through the house, you have this firearm still in your hand. At any point, did you open up the firearm?
I opened the cylinder on it to check to see how many had been used or was left in it, and closed it back up and started checking the house.
When you opened it back up, how many live rounds did it appear were left in the gun?
Just one.
And how many rounds does that .357 Magnum revolver hold?
It's a 7-shot.
So you knew that she'd fired, at that point you knew she'd fired 3 at or in your direction.
Yes.
You did not know what the other 3 had been used for?
Correct.
The last time you saw that gun, were all 7 rounds live?
As far as I know, I guess the last time it had been used was a couple years before, or sometime when Ashley had shot at some, and I assume she had reloaded it.
So Heath, you're walking through the house. You have this gun, afraid that maybe there's somebody else in the house. You said, I believe, that you tried to call Ashley.
Yes.
Did she answer?
No.
find her phone?
Found her phone. It was on a counter in our living room.
Was there a second phone beside it?
Yes.
Did you recognize the other phone?
I didn't really stop to look.
So you realize that Ashley's phone is there. Walk us through what happened next, Steve.
Checked our bedroom, bathroom, closet, other side of the bed, under the desk in there, and turned and started looking, going towards the other end of the house, and I glanced in our spare little third bedroom, and then turned and went into Carly's room, and that's where I found Ashley.
When you found Ashley, can you tell the ladies and gentlemen what you saw?
She was laying on her back and had her hands kind of across her, and a towel over her face.
Do you remember what color the towel was?
I do not.
When you saw her laying there, what's the very next thing that you did?
Checked her pulse, see, and kind of moved the towel, and then called 911.
And Heath, when you moved the towel, what did you see?
I knew she had been shot. There was blood around, but I don't really recall exactly where. Somewhere in the right side of her face there.
You said you called 911.
Yes.
What did you tell the 911 operator had happened?
I tried to immediately tell him I needed the police out, that my wife had been killed and I had been shot.
Do you remember telling them who had shot you?
I assume I said Carly on there, but I don't remember exact details.
Do you recall telling the 911 operator that, oh my God, she's killed her mother too?
I don't recall saying that, but it's very possible, I guess.
At that point, Heath, did you think that Carly was the one that had killed her mother?
I didn't know what was going on at that point. I kind of went into shock there.
At some point, and again, the ladies and gentlemen, Heath, have seen some of the body cam footage from that day, but at some point, someone from the sheriff's department does come to your house.
Yes.
Walk us through what you remember happening once he gets there.
I don't know much there other than I got out the front door and just laid down on the front porch.
And it's pretty safe to say that you were still in a state of shock.
Yes.
At some point, were you loaded up by the paramedics?
Yes.
And where did they take you?
Took me to Baptist Hospital ER.
And what was the reason for taking you to Baptist Hospital?
They wanted to get me checked out and make sure everything was okay. They knew it wasn't real bad or anything, so they just trying to be cautious.
But you had in fact suffered a gunshot wound.
Yes, they got me down to the ER and they put a piece of gauze, taped some gauze on it, and sent me back home.
And it went through your kind of right, like trap muscle area. How far? I mean, not to pick on you, you don't look like a very large man. He's pretty average size. I mean, would you agree with me that where your trap muscle is and your head are about 6 inches apart?
I guess, yes.
So that shot was pretty close to your head.
It was close, yes.
the gunshot actually, thank goodness, went kind of through and through, right?
Yes.
So you didn't require any surgery to remove the projectiles.
No.
In fact, Heath, I think you were actually, excuse me, I think you were actually released to go home that evening.
Yes, like I said, they tacked a piece of gauze on me, and I don't remember them doing a whole lot else.
And the night was probably pretty hectic as far as telling people what happened and what was going on. At any point, did you ever tell anyone that it was someone other than Carly Gregg that had shot you or Ashley?
Not that I recall, no, ma'am.
And to this day, you've not told anyone that you think that the person that shot you or shot Ashley was somebody other than Carly, have you?
No.
We talked a little bit about law enforcement being at the house that night. At some point, they kind of released the scene back over to you, right?
Yes, I think when I returned back from the ER, they had finished up and cleared out, and there was a guy had me sign a paper and went on back in.
Kind of saying the things that they'd taken from the home that night.
Yes, ma'am.
Heath, I mean, you go back home and they've taken some things out, but of course there's still, I mean, clear evidence that a murder had happened there, right?
Yes.
At some point, do you notify law enforcement about the garage camera?
Yes, on, I think it was Friday morning, I was looking through that SD card to see if it had caught anything. And of course the cops were looking all around, everywhere in the garage for various things, and had apparently not seen the camera. And they found the 4 videos that you referenced, and I called and told them I had found something else and they'd come pick it up or whatever, and they had still at that time not returned my driver's license to me, so they decided to bring that out.
And at some point they did actually get those videos from you.
Yes.
And to be clear, there was some confusion about an Apple computer and copying versus cutting.
I had moved those 4 videos over to my computer, and was just going to let them have the card with everything on it. And when I moved them over, it pulled them off the card onto the computer rather than like a copy and paste and making a copy onto mine. So the officers came back in and were talking to me about tampering with evidence and possible charges of messing with evidence, even though I called them out there to come get the card.
And to be clear, I don't think they ever told you they were going to charge you with tampering. They just explained that they didn't want it to look like somebody might have done that, correct?
No, he said we're trying to avoid having to charge you with tampering with evidence.
Okay. At that point, you're still pretty much in a state of shock, right?
Yes, there was 4 or 5 of them in my bedroom.
And in fact, if that was said to you, that would certainly not be indicative of what you would want to, how you would want to be treated, right?
I didn't know. I was just trying to be helpful at that point and figure out what had happened or why.
And I believe even on that day and after that, you did still continue to assist law enforcement in the investigation, right?
Yes.
At some point, you decided that you no longer wanted to communicate with the state or law enforcement, right?
Yes. After a few things that had happened, I went and got a lawyer.
All rise. Circuit Court of Rankin County is now in session. The Honorable Dewey Arthur presiding.
All right, please be seated. Let's see. Okay. All right, State Mississippi versus Carly Gregg, cause number 2024-34169. Please bring the defendant to the podium. All right, we're here by way of pretrial conference checklist, which means that the defendant has rejected any recommendation from the state. For the record, what was the last recommendation of the state of Mississippi?
Here, the state recommended 40 years in the custody of Mississippi Department of Corrections and agreed to not prosecute counts 2 and 3 of the indictment. Again, there were fines and no contact and things like that.
All right, Ms. Gregg, did you receive that recommendation of 40 years?
Yes, sir.
And it was your choice and your choice alone to reject that recommendation?
Yes, Your Honor.
You know, if she proceeds to trial, count 1, what's the potential sentence?
Life.
If the jury fails to affix the sentence at life, what's the sentencing range?
20 years to 40 years.
All right, and count 2, what's the potential sentence?
Between 20 years and life.
All right. She's 14 years old, so if the jury fails to affix the punishment at life, she's facing 50 years.
Give or take, Your Honor, yes.
Okay. And in count 3, what's she facing?
Another 10 years.
Another 10 years. So the jury will either acquit you, or you'll be facing 2 life sentences, or this court can sentence you up to 93 years. Do you understand that?
Yes, Your Honor.
It's your choice and your choice alone to proceed to trial.
Yes, Your Honor.
Have a seat. It says discovery is complete except expert reports from McNaughton experts. I thought I've ordered that, those be turned over 3 times. Has that been received by the state?
No, sir, Your Honor. And I just, before you walked in, got with counsel opposite and showed them 2 orders that were motions that he granted last time we were in front of you. The order granting our motion to compel their compliance with the mental evaluation analysis, and also the order granting the motion to compel compliance with Rule 17. May I vote?
Do you still intend on trying to offer experts at this trial?
Your Honor, we have an expert that's going to be doing an evaluation. We do not plan on contacting him.
All right. Well,
and Your Honor, just for the clarification, we're aware of the time constraints, and we know that we have to get our evaluation done. Our evaluations happen on Thursday. And
actually, the reports were due a month ago, Mr. King. I signed an order more than a month ago. Now, I'm not going to, there's nothing in front of me to rule on at this time. There's nothing in front of me to rule on at this time. All right. Says that there's some pending motions, anticipated motions to suppress urine test, and both sides think it'd be 3 days for trial. Is that correct by the state?
Your Honor, I believe it'll take probably a little more than 3 days. But there are additional motions that the state intends to file, certainly some motions in limine.
All right. By the defense?
Your Honor, I expect the trial itself to probably take 4 to 5 days.
All right. I'll remind both sides these jurors are getting paid a whopping $25 a day. So y'all drag this case out at your own peril. However, I'm going to give each side plenty of time to try your case. All right. All motions under Rule 16.1, the motion filing deadline is this Friday, August 30th, 2024. Under Rule 34.1, the Mississippi Rules of Criminal Procedure, all motions must be in writing and must contain a concise statement of the precise relief requested, and must state the specific factual grounds and specific legal authority. Failure to comply will result in the motion being considered procedurally abandoned or waived. Responses must be filed in writing before the close of business Wednesday, September 4th, 2024, or the motion may be considered confessed. Reply to any response may be filed if desired before the close of business on Friday, September 6, 2024. Under Rule 34.2, you must be in court on Tuesday, September 10th, 2024 at 9 o'clock for hearings on pretrial motions. All jury instructions must be pre-filed before the close of business on Friday, September 13th, 2024. This court will not entertain a request for jury instructions either party failed to pre-file unless there is good cause shown. Additionally, an editable copy of all instructions must be emailed in Microsoft Word format to sbutler@rankingcounty.org. All right, I need this attorney for the state. I've already signed off on this.
Yes, sir.
Oh my God,
Do I need to put the additional motions?
No, as long as the motions are filed by the motion filing deadline, the court's going to consider all motions both parties file. As long as they contain a legal basis and, some case law. All right, anything further from the state?
All right, I think the only pending matter, and this may be something that we address at the pretrial conference, is the defendant, and I don't have it in front of me, I think filed a motion to transfer to youth court that we've never heard.
You want to hear that on pretrial conference day, or do you want to hear it today?
Pretrial conference day.
All right, the court will hear that matter on pretrial conference day. Anything further from the defense?
No, Your Honor.
Best of luck to both sides. The defendant will remain in custody to await trial. Yes. All right. Court will be in recess for 15 minutes.
We all heard Carly screaming when you walked into the garage, from the garage into the kitchen on March 19th. How did Carly appear to you when you walked in?
Like I said, my initial thoughts were she was terrified, scared out of her mind. I still, to this day, don't think she ever even recognized me. Something was wrong there. I don't know what, but something was off.
Carly Gregg's stepfather, Heath Smiley, testifying at her murder trial. She also shot him. He survived. And his testimony, incredibly sympathetic to his stepdaughter. Amazingly so. Heath Smiley, Carly Gregg, Ashley Smiley, they all lived together. They were a family, but she's dead because Carly shot and killed her mother, shot her stepfather. He survived, and he is standing 100% behind her. I want to go back and remind you of the compelling arguments and the dramatic verdict in this case. And a lot of it had to do with the age of this defendant, who was just 14 at the time she shot and killed her mother.
Ladies and gentlemen, there's no doubt that Carly Madison Gregg is the one who killed her mom, Ashley Smiley. There's no doubt that she attempted to kill Heath Smiley when she aimed the gun right at his head and shot and hit him in the shoulder. And there's no doubt that she's the one who hid the camera, thus tampering with evidence in the refrigerator. And we would ask you that you go back there and you find her guilty of all three, because she was not insane at the time that this happened. She knew exactly what she was doing, and she knew the difference between right and wrong.
We've heard the testimony of Carly's stepfather, who has no reason to defend this child. It's not his biological child. He was very much in love with his wife. They were still in the honeymoon phase. You heard him on that 911 call. That was a man in shock, in grief, and in pain. You heard his testimony about feeling intimidated regarding his testimony in this case. But despite all of that, he has continued to tell the truth consistently from March 19th until his testimony in this courtroom today, and he continues to stand by Carlee to this day and support her. And he said, yeah, I've noticed that Carlee was experiencing memory lapses in the fall of 2023. It was bizarre. And while she was having a state of psychosis and an episode of acute stress on March 19th, she lost herself in what was the perfect storm. I am asking you for those reasons to please find Carlee Gregg not guilty by reason of insanity and finally quell this storm for Carlee and her family.
When he arrived home, opens the door, and gets shot at. He took the stand. He tells you to this day, that wasn't Carlee. The person that was shooting at him was not Carlee. It's real important. He's the last person that's seeing her right there as it's happening. This is the person who knows. This is the person that sees her every day, that knows Carlee. And yet, he's saying she's shooting at him. If there's anybody that has a reason to, disavow Carlee and say, hey, look, she shot me. I don't want to have anything to do. She killed my wife. He's sitting there saying, and he was doing it to his own detriment. And he's saying, that's not her. Something's wrong. That was not her.
The only thing that the defense wants you to do is to have sympathy for the defendant, to believe this story that she's made up after she's been arrested.
We, the jury, find the defendant, Carlee Madison Gregg, guilty of first-degree murder, guilty of attempted murder, guilty of tampering with evidence. Your sentences will be as follows. As to count one, the jury having fixed the verdict at life imprisonment, this court will sentence you to life imprisonment. As to count two, you'll be sentenced to life imprisonment. As to count three, you'll be sentenced to 10 years to serve.
Now, we saw a lot from Carlee Gregg's stepfather, but Carlee Gregg's biological father, Kevin Gregg, spoke with WLBT-TV in Jackson, Mississippi, and discussed Carlee, her childhood, and her trial.
I love Carlee, and I would love to have tried to help her the best I could. I kept screaming in my head, why couldn't you just have called me? We had really enjoyed ourselves, and she was a wonderful child, and she was obviously multi-talented, gifted. We loved each other. We loved that girl. That girl knew right from wrong. That girl is not insane. That was a very dumb defense, if you ask me. But I wasn't involved. Nobody ever called me.
All right, so you heard Kevin Gregg say, nobody ever called me. Nobody ever called me in this case. Well, the big news now is that the defense has filed a motion for a new trial. Let me put it up on the screen because it's really interesting. In an unaired portion of his interview, okay, not what was shown on TV, but the unaired portion of the interview, Kevin Gregg disclosed that Carlee was placed in equestrian therapy as a young child due to experiencing auditory hallucinations. Auditory hallucinations. They say, the defense says Kevin Gregg refused to cooperate in Carlee's defense, refused to talk to the state, refused to talk to the mental health professionals evaluating Carlee, and refused to come to any pretrial hearings or a single day of Carlee's criminal trial. So they're saying, this is new evidence. Auditory hallucinations. Meanwhile, Kevin Gregg is saying, no one tried to contact me. Let's bring back in the think tank Al Wunsch, Darnell Crossland, Jennifer Brandt. All right, Darnell, what do you think of this development? They're saying, listen, the father has this new information we didn't know about. He wouldn't cooperate. Now he's saying that she suffered from auditory hallucinations as a child. As a younger
well,
child, as a much younger
yeah.
child.
I mean, but she's not that old now, 14,
Right.
so it's not that far away. I mean, it's a small life. And whenever you have new information that could tend to make the outcome different, the court has an opportunity, an obligation to look into it. And when you have something that shows that she had some mental issues or hallucination, and it matches what the stepfather was saying, I think that's good grounds for the court to look into it and see if, in fact, they can offer a new trial.
Jennifer Brandt, your thoughts about this and the fact that Kevin Gregg is saying this now, yet he's saying no one called him, but the defense is saying he wouldn't cooperate.
Yeah, Vinny, it's crazy. I mean, reading that and hearing that he wouldn't even come to a day of trial, wouldn't support his daughter. I mean, you hear him now talking about her, what a great kid she is and that kind of thing, but where was he all this time and why didn't he step in? He is her biological father. I mean, what could have gone wrong between the two of them? She's a young child. She still is a young child. So what could be so wrong in this relationship? And that's a question in itself, you know? She obviously had some problems early on. Did he just abandon her? Did he leave her? What was her mental state and her mental health? And should that have been brought into the trial? I think that is all very relevant. And I think it's upsetting to hear that he wasn't, if it's true, that he wasn't even involved.
Al, I think there's a lot of cases where sometimes people don't want to testify, and that our system of justice has some mechanism to bring people to court who don't necessarily want to be in. What is it called again? What do they call that?
My Uncle Nuncio.
Yeah,
he's the one that can get anyone to court anytime. I just go, Nuns, go over there, take care of him, and they show up. It works every time.
Isn't there a piece of paper? A subpoena. So why wouldn't the defense just subpoena him? He's not cooperating. Oh, he won't come in and talk to us. Subpoena him, make him testify.
Because I think they were afraid that he was going to say partially what he said, which is that she knows the difference between right and wrong. And then there's the situation with regards to the equine-assisted therapy that he's bringing up, which seems to be for the first time. It seems odd to me that they did not find out about that. But equine-assisted therapy does not necessarily deal with schizophrenia. So maybe they were a little bit concerned that it was, you know, not necessarily a thing that was used for people who are, you know, schizophrenic. I mean, it's used for depression, it's used for overweight, there's a ton of stuff that they use it for. Schizophrenia is not necessarily one of them. But now you've got, you know, throw out everything, you know, go forward on it. I just think that if I was the prosecutor, I'd say exactly what you just said. Why couldn't you get him here? Why? It's not like you didn't know about him. It's not like there was.
All right, Al, before we run out of time, he's chomping at the bit. Go ahead, Darnell. I see you chomping.
Yeah, no, not really. You know, I was just really thinking, when it comes to these cases, the defense attorneys always want to know who's on their side. And it seemed like there was so many unanswered questions about this father. And as Jennifer alluded to, I mean, what type of guy is he? You know, he seemed like a wild card. He's not there to support them. And like Al said, he's saying that she's not crazy. So we simply tend to leave those people outside of the courtroom if we don't know where they're going to go. And I think that's what happened.
Yeah.
Okay, and save them for the motion for a new trial. There you go. All right, think tank staying with us. When we come back, that's not the only reason the defense says they deserve a new trial. We'll break it all down next.
March 12th, Tuesday, she writes, I think I had a psychotic break earlier. The whole ordeal was quite silly. I actually spoke with one of the voices in my head. Well, I didn't hear them until earlier today, but I only do then. My particular friend and I were practically screaming, bloodthirstily and ravenously. Thank God, physical confrontation was not, and I think it's fruitively, possible. I sound crazy.
That's straight from Carly Gregg's journal, read by Dr. Andrew Clark during the course of her case. So her defense now, after the conviction and, you know, life in prison, making a motion for a new trial in front of the same judge who heard this case. They also have some complaints about the jury and the jurors' ages. Take a look at this one. I've never seen this one before. Carly was not tried by a jury of her peers. Carly was 15 years old when her trial commenced on September 16, 2024. Mississippi believes that only a person 21 or older possesses the maturity necessary to make decisions about the life of another. You've got to be 21, apparently, to serve on the jury down there. However, Mississippi also holds that a 14/15-year-old possesses the maturity necessary to make decisions about plea offers, understand the nature of the alleged offenses, comprehend the nature of the charges against them, effectively participate in their defense at trial. These two fundamentally opposing legal standards cannot be rectified. And, you know, they've got a point, little common sense. You got to be 21 to be on a jury, but you could be 14 and tried by a jury. Let's bring back in our think tank Al Wunsch, Darnell Cross, and Jennifer Brandt. I don't think they're going to win, but it's an interesting argument, Jennifer.
It is an interesting argument, but I agree. I don't think they're going to win. I mean, she's old enough to be tried in this court. She allegedly committed an act that is, you know, quite dangerous and quite adult, not something that a child would normally do. And I think she should be judged by her peers. These are her peers. These are other people in the community who are also being affected by this alleged crime. So I don't see her being judged by a bunch of 14-year-olds. I don't think that is going to happen. So I don't think she's going to win on that one. But I agree, it is an interesting argument. And, you know, I just never heard it before, but I think it's a good one. It's one that they should throw in with the rest of them, but not a winner, I would say.
All right, they have another one regarding something. So this is regarding the testimony of Carly's therapist. Here's from the motion again. The testimony was of no importance in the facts in Carly's case and was elicited for the sole purpose of prejudicing the jury. This fact is highlighted by the state's erroneous belief that Mrs. Kirk, who was the therapist, was concerned about Carly reading this book as the title was underlined in her records, without realizing that it was simply grammatically proper to underline the titles of novels. Let's take a look at how that went down.
The entire book, very difficult book, about a psychopath who lives in Russia, and he is poor. He is a student. He is very intelligent, and he comes on hard times, impoverished, and he has this obsession with this obsessive thinking of basically planning to murder a woman with a hatchet.
And Rebecca, in your notes, you'd actually underlined the fact that she was reading that book.
Well, that was just for grammar, because you're supposed to underline a title of a book if you can't italicize it.
Okay.
All right, Al, it seemed the state was trying to make a big deal that the therapist was underlining the name of the book, Crime and Punishment, when, like, that's how you grammatically do it.
That's how you grammatically do it. That is a ridiculous point by the state with regards to this. I mean, first of all, the book Crime and Punishment is a 500-page book. It is not necessarily a very difficult book, but it's not necessarily geared towards a 14-year-old or a 15-year-old. It's a story of Raskolnikov, who is an impoverished student who ends up, you know, murdering an old woman. Okay, and he's talking about everything that went on with regards to his intelligence, and he couldn't understand why he was, you know, impoverished, and all these other people with less intelligence were doing better than him, and things along those lines. To say that underlining meant that was her concern is absolutely just ridiculous.
All right, so we'll give a point to the defense there, and if you need a copy of the book, I think it's on the second shelf behind Al. Now,
it's right over here.
Exactly.
Signed
by
Dostoevsky.
Exactly. Okay, let's get to one more of these reasons that they are making a motion for a new trial. It's about the testimony of Dr. Jason Pickett. Dr. Pickett's testimony regarding his undiagnosis of Kevin Gregg, that's the biological father, was improper, unethical, and highly prejudicial at trial. Pursuant to the ethical guidelines established by APA, the Goldwater Rule prohibits and enjoins psychiatrists from offering opinions about the mental health of someone they have not personally examined. Here's the testimony of Dr. Jason Pickett regarding Carlee and her biological father.
To me, it made the diagnosis very skeptical of Mr. Gregg to have bipolar disorder. The very limited and sparse records from Dr. Hardy made it very questionable. My opinion is that, based on reading his report, that some of his opinion of diagnosing Carlee with bipolar disorder was that he took Dr. Hardy's notes for face value. And when I read Dr. Hardy's records, importantly, he never said, Kevin has bipolar disorder and I reviewed the records from his recent hospitalization, or he has bipolar disorder because he met these criteria. He essentially just says he has bipolar disorder and he used to drink and maybe do a little bit of drugs, but he doesn't do any of that now. And so I really, only having 3 visits for 1 hour with no collateral records, minimizing his substance abuse and then prescribing him the controlled substances he did, I just wonder, did he have all the facts? And if Kevin doesn't legitimately have bipolar disorder, well then Carlee, it's a lot less likely that she would.
Okay, Darnell, does the defense have a point here? And basically what they're saying is that this expert for the state did not examine Carlee's father, so cannot come to a conclusion that he's not bipolar. And his conclusion that it's less likely that Carlee is not bipolar because her father's not bipolar is unethical. I mean, it's a subtle thing, but is this a big deal?
It's a mounting thing, right? So you have to put everything before the court, and definitely before the appellate court. So they're basically saying he can't opine about this because he's not qualified, and the unethical word is huge. So it's unethical for him to do so. So therefore, the judge has to now take away everything he said and act like it didn't happen. And not even that. Not that it didn't happen, but they have to conclude that that went improperly before the jury, and now it may have swayed the jury. So now we need to give this case to a jury that gets the proper information, ethical information, and that's what's happening. I think they're right on all fours with that. You have to put it in because it's a building, a little of this, a little of that, and then and then hopefully you get to a new trial.
We shall see. Great job as always, Al Wunsch, Darnell Crossland, Jennifer Brandt.